22 CF 363, State of Wisconsin versus Taylor Schabusiness. State appears by Deputy District Attorney Saunders and District Attorney Lizay. Schabusiness is here, as is her attorney, Mr. Frail, on the court's calendar. Really for a Daubert type hearing this morning to address Dr. O'Donnell, who Mr. Freilich had submitted as a potential expert for the responsibility phase. So, Mr. Freilich?
Thank you, Your Honor. Well, the defense does have Dr. Diane Litton, PhD, as an expert to testify in phase 2 of this trial, the NGI phase. I did confer and consult with Dr. James T. O'Donnell yesterday after court to further talk about his opinions in this matter. I've had a number of discussions with him. I know that he is a pharmacologist who has lots of experience and has testified as an expert in the field of pharmacology in the past. I shared with him some of the concerns that the court had with regards to the 4 points of his trial opinion that was discussed yesterday. The defense had retained him some time ago, and he did testify at a motion hearing, I believe, back in June on legal issues related to the statements and other issues of that sort. After further analysis, after further contemplation and discussion, the defense has decided to not call him in phase 2 of this proceeding based on the comments that court made and some of the concerns that the court shared. We do not believe that it would be helpful at this point in time, and so we're going to not call him at this phase of the case.
Okay. And I respect that opinion, or that decision rather, Mr. Freilich. I want to indicate that I raised the concerns yesterday because I was very much interested in focusing any testimony at this hearing today on areas where I thought some testimony would need to be directed. I wasn't deciding what was going to happen at this hearing. So I just want to make clear, I didn't render a decision. That's why I'm here this morning to listen to testimony. But I respect your decision to call in. That is your decision, and you're right. You have another expert that you're calling who has already testified in this case as well. So there's no need for a hearing on that this morning. Obviously, the jury isn't going to be in for another 45 minutes, so we can't get going. We have a little bit of extra time. But a couple of things. First of all, does the state have anything you want to share on that, Mr. Saunders?
No.
Okay. A couple of things. I was asked by security this morning, Mr. Freilich, about whether your client needed to be in street clothes or whether simply the jail scrubs was fine. Frankly, I think the answer probably is she could have come in jail scrubs because that's the point of the proceeding we're at. On the other hand, I didn't care one way or the other. I'm sure security would have preferred it the other way, but I see that she's here in street clothes. And that's something that you wanted, Mr. Freilich, is that correct?
Yes, Your Honor.
All right, so that's been accomplished, and we'll do it that way. And when the jury returns, I think all I would do is give them instruction 603. And I don't know if the parties have that in front of you. If you don't, I'll get you a copy of it. But 603, 603 has a few what I'll call options. The first option is if the first phase was resolved with the plea of guilty or no contest, add the following, and then I was to insert the elements. That didn't occur in this case. So the only I would suggest taking to 603 is that the defendant has been found guilty and then the offenses, as I've done in these instructions so far, and then indicate we will now proceed with the second phase of the trial. During the second phase, you will be asked to determine whether the defendant is not responsible by reason of mental disease or defect, and then continue to read that instruction. First of all, I saw when I mentioned about whether or not you had it in front of you, you nodded, Mr. Saunders, you have it in front of you.
No, I don't. I
You
read
do?
this more.
Well, let me just make 2 copies. I'm assuming you need a copy as well.
I've got it in my binder.
Then I'll make Mr. Saunders a copy.
Thank you, Judge.
So I'll start with you, Mr. Fairley, because you have it. You probably looked at it as I've been talking. Any objection to my setting out 603 out in that fashion?
Makes sense, Your Honor.
Mr. Saunders?
No objection.
Okay. So that's what I'll do. And then I guess the only other issue is the order of questioning. You know, the burden of proof now shifts to the defense. Generally, the party with the burden of proof goes first, although this is kind of one of those cases where the state generally is perceived as going first. Mr. Saunders, preference?
No, I agree. I think the defense has the burden, so they would start opening
Okay,
statements, we would respond, and then they would call witnesses.
Mr. Fairley?
That makes sense as well. I believe, in talking to Mr. Lissay, at the end, at closing, then I would have the rebuttal.
Right.
So,
That makes sense. So that's what we'll do. I'm going to keep you under the same timeframes I had for openings and closings during the guilt phase of the trial. Okay, anything else to take up? I'll go briefly modify that jury instruction. Anything else to bring up, Mr. Saunders?
I don't know if the court also wants to read the opening statement instruction too after 603. I don't know if it's necessary or not, but
I can. That is not any objection to that, Mr. Fairley?
no, Your Honor.
Okay, I'll get the opening statement instruction. The proposed jury instruction guide is pretty sparse as to what they suggest we read. So, and frankly, at the end as well, there's 605, but nonetheless, we'll talk about that later. I'll get the opening instruction, the opening statement instruction. I'll read 603 first, then I'll read the opening statement instruction, and we'll go from there. Anything else, Mr. Saunders?
no, thank you.
Mr. Fairley, anything else?
Nothing else. Thank you.
Okay, well, the jury will be in at 9:15, so we have a little bit of time, and we'll be back on the record at 9:15. We're in recess.
Thank you.
The jury is present. Is there anything that we need to take up before we have a jury yet, Mr. Sanders?
Briefly, if that's okay. Sorry.
Have a seat.
So I told counsel, it doesn't seem like there's a large issue, but I just wanted to make a record of incidental contact I had with the juror. I was entering the restroom, he was exiting the restroom, and there were reflexive warning comments. I then realized he was a juror. There wasn't any further contact. That was about 8:40 a.m., so I was admittedly a little surprised to see a juror here this early, but I just wanted to make a record of that.
Anything you want to say to that?
Your Honor, Mr. Saunders told me about this. I don't believe it's really an issue at all.
These types of things periodically happen, and usually it's incredibly innocuous. So we give the instruction to the jurors not to talk to the attorneys and parties not to talk to the jurors. You see somebody, you feel like you're compelled to say hi. In this case, Mr. Saunders, it seems like wasn't even aware that it was a juror. He was not even expecting to see a juror. Sometimes the jury's sitting there and you don't study their faces so you know what you're dealing with and satisfied given what's represented. No intent in what occurred, and the exchange was innocuous and no use to me. But I appreciate you letting me know, Mr. Saunders. Anything else before we bring the jury?
No, thank you.
Mr. Fralick?
No, Your Honor. Thank you so much.
Very good. And we will we'll bring the jury. Okay, be seated. Ladies and gentlemen, welcome back. I hope you had a good evening. This is the second phase of the trial, and I'm going to give you these instructions. The defendant has been found guilty of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. We will now proceed with the second phase of this trial. During the second phase, you will be asked to determine whether the defendant is not responsible by reason of mental disease or defect. Before you may find the defendant is not responsible for the criminal conduct, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, the defendant had a mental disease or defect and as a result lacked substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law. This issue will be presented to you in the form of two questions. First, at the time the crime was committed, did the defendant have a mental disease or defect? Second, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question, yes. If you find the defendant is not responsible for the criminal conduct, the defendant will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. The only issue at this second phase of the trial is the defendant's mental condition at the time of the offense. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. And ladies and gentlemen, because this phase of the trial, the burden of proof shifts to the defense, the order of questioning and presentation will change, and Mr. Freilich will go first. Mr. Freilich, are you prepared to make your opening statement?
Yes, I am, Your Honor.
Very good. Go ahead.
Thank you. May it please the court, ladies and gentlemen of the jury, Mr. Lissay, Mr. Saunders, prosecutors for the state of Wisconsin. You're going to hear some testimony in this case from the defense expert, Dr. Diane Litton. She's from the Menasha area. She's a PhD. She's a forensic psychologist. You're going to hear testimony from the state doctors as well, Dr. Matthew Seipel and Dr. Christina Engine. The burden does shift to the defense in this particular case. We're in phase 2 now, and the burden shifts to the defense, to me, to ask you to consider whether the defendant, Taylor Denise Schabusiness, is responsible or is not responsible for reason mental disease or defect. And Wisconsin law, under Wisconsin statutes 971.15, does require the defense to satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crimes were committed, which was February 22nd of 2022, that Taylor Schabusiness had a mental disease or had a mental defect, and that as a result, she lacked the substantial capacity either to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. So that's packed with a lot of information that you're going to have to consider. I did tell you yesterday that you're kind of like analysts. You're going to have to listen to the testimony, listen to the facts, assess the credibility of the witnesses, assess the information that you're receiving, and then you'll have to make some decisions and considerations on these important legal issues. The defense did retain Dr. Diane Litton. She interviewed Taylor Schabusiness. We believe that the evidence will show that she did a thorough evaluation of Ms. Schabusiness's mental status, that you will hear about Dr. Litton's extensive experience in the field of psychology. When you have experts, you kind of heard from other experts, and they have a resume or a CV. In the field, we say CV, curriculum vitae. It's a list of their experience in training and education. And you're going to hear that Dr. Litton has been a psychologist since 1993, that she has extensive experience, that she has approximately 3,000 hours of postdoctoral training, that she conducted hundreds of forensic evaluations and GI competency evaluations, things of that sort. You will hear testimony that she worked at Mendota Mental Health Institution here in Wisconsin, that she looked at many different evaluations performed on Taylor Schabusiness, including from Dr. Tracy Lucetta, Dr. Matthew Seipel, Dr. Christina Engine, Dr. Deborah Collins. And you will hear that Dr. Litton, we believe she'll testify that she looked at a whole myriad of records, including jail records, mental health records, a court order, an order for civil commitment, mental health order, an order to take psychotropic medications, basically a medication order. She will, I believe, testify that she reviewed Nicolay Psychiatric Center mental health records from Brown County. She will talk and testify about her contacts with Ms. Schabusiness on the different occasions that she met with her. One being a situation where a chair was thrown by my client at her before I got involved in the case. She will testify that she did have another interview with her at the jail, and she asked me to sit in. So you're going to hear about all of her findings, her observations, and her opinions in this particular case. We believe that she has extensive experience. She's been in this field for a very long time, and that you need to pay close attention to what she says and give her opinions strong consideration. Give it due weight. And we believe that her testimony will be that she's of the opinion that Taylor Schabusiness does qualify for the NGI plea based on her diagnosis of a serious mental disorder. And that she has some other opinions, and she'll tell you about those when she testifies. You will hear, I believe, testimony from my client's father, Arturo Coronado. And I believe that he will come here. He's been summoned by the defense by subpoena to answer some questions about his daughter growing up, how she was, what kind of issues or problems did she have, what kind of mental health issues, and what he did to try and help her get treatment. You will hear from Dr. Litton about my client's mother, that she lost her mother at a young age, and that was a pivotal event in her life. Dr. Litton will also provide some testimony about the fact that she believes there may have been a budding personality disorder, and that she saw a really disturbed teen when she assessed all of the school records. She looked at all the school records and did a table or a chart. She looked at the mental health history. She did a one-page chart on that. The burden of proof in this case does rest with the defense on the NGI issue. I think that the testimony from all of these different professionals, these different doctors, these psychologists who talk about behavior and things of that sort, you can hear their testimony about all of the different problems, all of the different mental health issues, all of the different behavioral issues that Taylor Schabusiness had growing up as a kid, as a youth. She had a lot of obstacles that she had to face growing up. We believe Dr. Litton will also provide some testimony about my client's prior treatment with antipsychotic medications. She will testify about my client going off these antipsychotic medications sometime after her inpatient treatment in 2021. And Dr. Litton will set up and provide the background history and information on Taylor Schabusiness's life and upbringing. So the defense does have the burden of proof on this issue of whether our client is responsible for these crimes. But we believe that the testimony and the evidence will show that at the time of the offense that she did have a mental disease defect. We believe that the information and the testimony will show and hopefully lead to you to conclude that she lacked the substantial capacity to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. And what I ask is that you just sit back, carefully listen to what these experts have to say, and then render a fair and just result. Thank you.
Mr. Saunders, are you prepared to make an opening statement?
I am.
Go ahead.
Good morning. So when I said an opening on Monday that this case is about choices and responsibility, this is what we're referring to, right? The responsibility phase is what we're here for now. Essentially, you're being asked, what was the defendant's mental state at the time of the she's convicted, and whether she should be responsible for that. Let's address the obvious. What Ms. Schabusiness did to Shad is disturbing. It's conduct we don't see often. It's conduct that you may hear about and think, my gosh, that person must not have been in their right mind when that happened. I'm not going to sit here and try to convince you otherwise. But you've already carefully listened to the evidence and followed the law that the judge gave you. And you'll do so going forward as well. Because you will be told what a mental disease or defect is and what it is not. A mental disease is not antisocial conduct. It's not conduct brought about by use of a controlled substance, a temporary mental state caused by a controlled substance. A person is not mentally ill just because they commit something that's unnatural, so enormous that is beyond comprehension, right? Construct those are not disease or defects. So as disturbing as the conduct you already heard about is, and may be, that's not where the analysis ends. You'll hear from several experts. Defense already went over Dr. Litton and her qualifications, and how she supports Ms. Schabusiness's NGI plea. But you'll also hear some issues with Dr. Litton's methodology, her analysis, and ultimately her conclusions. The state will call several psychologists of its own, both of whom were actually court appointed, not by either party, by the court, when they did their analysis and meetings with Ms. Schabusiness. Dr. Matthew Seipel will talk about some of the issues that he had with Dr. Litton's methodology and her conclusions, testify about those. You'll also hear from the court-appointed expert, Dr. Christina Engen. Again, came here on a court order, not retained by either side. And she'll tell you that she does not believe Ms. Schabusiness is suffering from a mental disease or defect, or that she was unable or lacked substantial capacity to conform her conduct to the requirements of law or appreciate the wrongfulness of her conduct. Okay? So you'll hear from a variety of witnesses, some of whom are experts, who are witnesses, civilians. You'll hear about, and you've already heard about, confounding all of this is the defendant's drug use immediately before the offense. We've all heard about that. Defendants admitting that and acknowledging that. You'll hear about how methamphetamine has those effects, has effects of psychosis, that has that result in people. And again, it's not a mental disease or defect if you're using controlled substances and it causes that result. So you'll hear from these experts and witnesses, but ultimately, in our state, whether somebody is suffering from a mental disease or defect is a jury determination. It's up to you based on the facts and opinions that you hear. Certainly the opinions of the experts will be valuable for you, but you've already heard all the evidence. You know more about this case than any of these experts likely do. You heard testimony about Ms. Schabusiness's mental state both before and after, in close proximity to the offenses that she's convicted of. You've heard her friends, her roommate, officers who had contact with her, Mr. Hendricks, Ms. Pakinich, describe their interactions in close proximity to this offense and reported nothing out of the ordinary, some of whom are her friends who've known her for quite a while. Mr. Gannon, Mr. Tomes, you've already heard about their observations of the defendant. But more importantly, you saw the defendant's own words. Hours after all of these offenses occurred, really close proximity, you saw her be able to recall, be able to talk about it, and more importantly, you saw her mannerisms, how she was talking about it. Did not appear anyone was suffering under some manic episode. She's calmly talking about it with officers, providing information that is consistent with everything they're seeing. What does that indicate? She's aware of what's going on. She remembers everything. This isn't somebody who is not appreciating what happened. So that's why we call all these experts, but ultimately at the end of the day, it's a jury determination. It's a factual issue for you. And the state believes that when you hear all the heard first is that you'll find the defense has failed to meet her burden. That she should be held responsible for the conduct that she's convicted of and what she did to Shad. Thank you.
Okay, Mr. Freilich, are you prepared to call your first witness?
I need to confer with Lieutenant. Oh, yes. My witness is on his way up, Your Honor.
Okay.
Thank you.
They'll give you those right there. They want their notepads back. Okay. Mr. Freilich, this is,
Arturo Coronado.
sir, if you could just, if you stay standing and turn and face her, and as best you can, raise your right hand.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter, now before the court, so help you God. Please proceed and state your name for the record.
Arturo Coronado.
Okay, Mr. Freilich, the witness is yours.
Thank you. Mr. Coronado, good morning.
Good morning.
Sir, how old are you?
51.
What is your date of birth?
5/24/72.
Are you currently married, sir?
I am not.
Um, You are living in Green Bay, correct?
Yeah, you know that, Chris.
And your daughter is Taylor Denise Schabusiness, is that fair?
She is.
Who is her mother?
Marla, of
And you were married to Marla for a while, sir?
course.
How many years was it?
We were married about 10, together about 15, 16.
Did you live together in Wisconsin or some other state?
Illinois,
Illinois.
Illinois and Wisconsin.
And where was your daughter Taylor Schabusiness born?
In Evanston, Illinois.
Does Taylor have a sister or brother?
She has a brother that passed away last year.
What was his?
AJ, Arturo Drive. AREP,
Why did he pass away? What happened?
July 1st, last year. Motorcycle accident.
When you were living in Illinois with your daughter Taylor Schabusiness, was she ever brought to a hospital at all?
No.
Okay. Did she ever receive any mental health treatment when you lived in Illinois?
No.
Did something happen to Taylor's mother at some point?
She passed away.
Okay.
She passed away May 20th, 2009. In her sleep.
Okay. Did that take a toll on your daughter Taylor?
Well, of course.
Can you tell me a little
Took a
bit,
toll
sir?
on my son as well and me.
Okay. It took a toll on everybody, correct?
But yeah,
And when her mother passed away in May of 2009, how old was Taylor?
11, probably 11 and a half.
Okay.
My
Yeah.
son and daughter were, about 9 and a half, 11 and a half years old.
Okay. Did Taylor go to school that day that her mother passed away?
I tried to get them to go to school, but they knew something was going on.
Okay.
They came back.
Can you describe a little bit how the death of Taylor's mother took a toll on her, or impacted her? Can you give me a little bit of commentary on that?
Well, they were pretty young. I mean, obviously, their mom's not around anymore. And, Marla was ill. So just, I guess they kind of knew what was going on, but it was unexpected. We watched the movie the night before and fell asleep and woke up and my wife was already cold. Pretty bad.
You
She's laying next to me.
And what about the kids? What about Taylor? Did she see her mom in that state?
They did not see. No, I did not allow that.
Okay. But were the kids in the house?
They were upstairs in their bedrooms.
After that occurred, did you see any changes in Taylor's behavior, first of all?
She's a little rambunctious. Nothing. I mean, she played volleyball. She had a good amount of friends she hung out with. She was a normal kid.
Did things change at all for her?
I wouldn't say too much. She got in trouble a little bit at school, but I don't know, something with a band instrument.
What happened with that?
She just took somebody's band instrument
And
then returned it, but nothing major.
when did you come to Green Bay? What year? Do you know?
2000. I started working here in 2007.
2007. Where did you work at?
I worked for Verizon
Okay.
before it was GTE, then turned into Verizon.
Um,
18 years.
and when you came to Green Bay, did Taylor go to school here then?
Of course.
Of course. Where did she go to school?
She went through the Howard Somical School District.
And did she go to Bayport High School as well?
Yes, sir.
Did you get information that she was having issues at school?
Well, yeah.
Can you?
From what I can recall, just normal just kind of acting out, I guess. Just there's a couple of little instances that happened in high school, but it's kind of why I yanked her out of there and sent her to Texas so she could graduate and get away from the issues that were going on here.
She went to Texas to live with her grandparents.
Correct.
When was that, do you know?
2017, I believe. I'm not sure.
Okay. How old was she in 2017? Do you know?
She was 16 and a half, probably 17.
16, 17. How long did she live with her grandparents then in Texas?
About a year, a little over a year until she graduated. Maybe 2 years. About a year and a half.
That could Texas.
That's correct.
Was there a point where she got pregnant?
Well, about a year and a half ago, maybe.
Okay. And
Yeah.
she had a baby, correct?
Yes, she did.
And the baby is currently living in Texas with the grandparents, correct?
Yeah. How is that relevant to anything here? Why do we need to talk about him?
Let me ask you this. So before the baby was born, she played at Nicolay Psychiatric Center.
Before the baby was born?
Yeah.
Possibly.
Did you see her at the Nicolay Psychiatric Center?
Oh,
when she was
yeah,
there?
yeah. I'm sorry. It's just so much going on.
It's through Brown County.
Yeah, I went to take her there myself, actually.
Okay. Why did you
Yeah.
take her there?
She just wasn't in the right state of mind.
Was she suicidal?
Probably,
Was she psychotic?
I guess.
Objection, I don't think this witness has the ability to answer that question.
Rephrase the question.
Okay. All right. Was she experiencing like hallucinations?
She
and
just,
things?
yeah, she was not in the right state of mind at all. So I feared that she would hurt herself. So that's why I took her. And we both agreed. We both went there together and tried to get help. And then ended up releasing her, and she came home, and that was about it.
Okay. Was she prescribed some medications and things like that?
She was at that evening, no, but yeah, she has been on some medications that she'd never taken pills. I mean, they kind of made her up even worse.
Did they cause her to hallucinate or cause her to have?
I think
Problems?
it all started with a Seroquel that was taken, back, I don't understand too much about those prescription drugs, but they never agreed with her at all.
And do you know the other medications that she was asked to take?
ADHD, Adderall, I believe.
Anything about Haldol?
I don't know.
Okay.
But I know she was prescribed some stuff, but I don't know the names.
Did you talk to some of the doctors or psychiatrists at the Nicolay Psychiatric Facility?
Judge, I'm going to object. I think this witness can offer his observations and the facts that he's aware of from what he observed of Ms. Schabusiness with respect to what he learned from doctors about her mental health conditions. We have professionals who are going to answer questions based on the records. Those people are better equipped to answer those questions. The information he received from doctors is hearsay.
It's not hearsay. I didn't ask what they said. I just asked if you talked to the doctors, Your Honor.
Sure. So the question that's pending isn't asking for hearsay. The made because that's where we're headed. So he can answer the question that was just asked, and then I'll just indicate, Mr. Freilich, that objection is probably coming if you go to the next step. But the question that's pending can be answered. So I think the question was, did you talk to anybody at Nicolay?
I did.
Ask another question. Mr.
Okay.
Freilich.
Did Taylor live with you in Green Bay for a while?
For a little bit, yeah.
Was that in 2021 or what year was it?
I believe so, yeah. But again, speaking to them and, her being an adult, they really, even being a father, weren't allowed to disclose anything,
Right.
you know.
Sure. When she lived with you, sir, what address did she live with you at?
1130 Moraine Way.
And how long did she live with you?
Just a few months.
Did it ever come to a point where you didn't want her to stay there anymore because her behaviors were getting worse or her mental status was getting worse?
No, I love my daughter, so I do whatever it takes to help her out.
Did you ever review any of her records at all?
Objection. I don't think he can testify to the content of, again, I think it's the same objection. He can answer whether he reviewed them. He can't answer anything about the content of the record.
Your Honor, the state, what they're trying to do is they're trying to anticipate an objection. They know this one is not an objectionable one, in my opinion. And any good parent, when you go to the doctor, you're going to talk with the physician or the psychologist or whoever it is about the status of your child. So I'm just
Yeah.
asking that.
It's not like I didn't try. I tried talking
Hold
to
it,
her.
wait. So I'm going to overrule the objection at this point, and the question can be asked. Mr. Why don't you ask it again so that witness.
Your Honor, I forgot. So hopefully
Did you review some of the records of your daughter? Did you review any of the records?
Like at the facility.
Yes.
Again, she was an adult at the time, and I can't. Yeah,
the
she
answer
was.
was no,
She
Mr.
was.
Freeland.
Yeah.
when she was living at your house, sir, on Moraine Way, was she ever experiencing or experiencing any hallucinations or anything like that?
Yeah.
Can you tell me about that?
Just know that she wasn't in the right frame of mind. Kind of see things. She'd like to walk around, and we take a walk, cemetery, just right down the street. But she just needed, just to kind of get out and walk around and, I guess, ease her mind.
Did you have concerns about her from a physical or mental standpoint?
Always.
Okay.
Always.
All right. Thank you. Nothing further. I appreciate that.
Do you have any cross-examination?
Briefly. Mr. Renato, are you aware of whether or not your daughter was employed during the time that she was residing with you on Moraine Way?
She was not at the time at that. No.
Do you know anything about her employment history as an adult?
Sure.
And had she held jobs in the past?
Oh, yeah.
Do you know where she worked?
She worked for Saputo. She worked a couple of years, Saputo, 3.5 years probably.
And is that relatively recently? Prior to her arrest, of course.
Yeah, right. Prior to,
And
she was doing really well there too, until her boyfriend / husband got out of jail. That turned everything upside down.
in part because of the methamphetamine use, right?
Yep.
So Taylor was doing pretty well, and then she started using the drugs.
Yeah.
No further
Pretty
questions.
bad drug too.
Anything on that, Mr. Freilich?
What was the drug?
No, meth, heroin, whatever else. I don't know.
Marijuana?
Yeah, I don't know. The kid was already doing that shit. Just a fun loser and get my daughter involved in that shit.
Thank you, sir. Nothing else.
Anything on that?
No, Your Honor.
Okay, thank you. You can step down.
I love you too. Go Carol.
Next witness, Mr. Freilich.
I call Dr. Diane Litton, PhD, Your Honor.
doctor, if you want to just step right up over here. Right up over here.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter, now before the court, so help you God?
Yes.
Please have a seat. State your name for the record.
Diane Lynn,
Okay, Mr. Freilich, then the witness is yours.
Thank you, Your Honor. Good morning.
morning.
State your name for the record again.
Diane Litton,
Can you do that?
Lytton.
And what is your occupation?
I'm an independent forensic psychologist
Where is your office?
in Oshkosh, Wisconsin.
And are you a PhD?
I am.
Does that make you a licensed psychologist?
Well, I earned the PhD first and then became a licensed psychologist.
Could you briefly provide me with your educational background?
Sure, I have a bachelor's degree, a master's degree, and a PhD doctoral degree. In all three are in the field of psychology.
How long have you been a licensed psychologist?
June 1993.
And did you work for UW-Madison?
I had my PhD program at UW-Madison. I was during the graduate program, I was what's called a research assistant for the professors, for my professor. So that was my work when I was getting my PhD.
Okay. Initially, when you got your PhD, where did you work?
I worked for the University of Wisconsin, initially in an internship, administrative internship through University of Wisconsin system. I did that for a year. And then I became a research scientist at UW-Madison.
Did you work at Mendota Mental Health Institute?
I did.
Could you tell me a little bit about that?
After taking off about 5 years for family matters, I then retrained to become a clinical licensed psychologist. And that took me 3,000 hours at Mendota Mental Health Institute in Madison. And then they hired me as a staff psychologist. And I was at Mendota for about 7 years, 1991 until 1987, when I became independent forensic psychologist. And I was a therapist too for some years too.
Okay. As a psychologist, do you conduct NGI evaluations, competency evaluations, psychological evaluations?
Yes.
What kind of patients do you treat as a forensic psychologist?
A variety. The ones inpatient at Mendota Mental Health Institute in Madison, we used to have what called the adult and teenage and child, not forensic units, but child units. For a while, I was on a juvenile adolescent unit, and then I worked for a couple years on what's called civil unit, adults. They're no longer at Mendota now, but then the last part of that 7 years, I was in the forensic units, people who were committed under the insanity, NGI. And then also, so most of the patients I dealt with were had been found not guilty by reason of mental disease or defect, and the other patients were there for competency to proceed to trial evaluations. I had both.
Did you also deal with guardianships?
Not at, well, peripherally when I worked at Mendota, but since being privately employed, I've been do numerous guardianship evaluations for Outagamie County.
Had you also been involved in doing sex offender evaluations as well?
Yes,
Now, you have a curriculum vitae, correct?
yeah, very small one, yeah, resume,
And you did provide that to me, is that fair?
yes.
Council, just to clarify, we're starting over with numbers. This is exhibit 1.
Okay.
Thank you, Judge. Can I have a motion to approve? I'll show you what's about that.
Yes,
Can you tell me what that is?
that's my brief resume.
And does your resume or curriculum vitae contain information about your educational background?
Yes,
Does it contain information about other patients or cases you've worked on?
well, it summarizes my jobs over since 1975, so yeah.
Okay.
And the type of cases that I do for the last 32 years?
Okay. And your license is still in effect, correct?
Yes.
Is everything in the curriculum vitae exhibit 1 true and accurate as of today?
Well, except I wasn't able to do the online renewal of my American Psychological Association membership. I found that out this year, so I have to call them up and do that. So that's the only thing. As far as I know, that's the only thing that's not accurate.
But you're licensed in the state of Wisconsin.
Correct.
Offer exhibit 1.
Any objection?
No.
One will be received.
Now, you provide with some background information about this case,
Yes.
and were you provided information from prior counsel and from me?
Yes.
What kinds of information did you review in this case?
It was voluminous, and I asked for more information too. The records, though, discovery included the criminal complaints for the offense, prior offenses from 2020. That's the police records and the formal criminal complaint. And then inpatient, a 21-day inpatient psychiatric hospitalization at Nicolay.
Can I stop you right there? Did you receive those documents?
Yes,
Did you receive the order for civil commitment?
yes,
Did you receive an order for psychotropic medications for Taylor Schabusiness?
yes,
And you looked at those legal documents?
yes.
What year was that? Do you know?
Yeah, which part, which,
When was order entered? Commitment order?
2021, I believe, for 6-month order for civil commitment and the order to treat.
I apologize for interrupting you, but Your Honor, can I approach?
You may.
I'm going to show you what's been marked as exhibits 2 and 3. First, could you identify what exhibit 2 is?
2 is a state of Wisconsin, Brown County order of commitment.
Is that for Taylor Schabusiness?
Yes,
And exhibit 3?
that is a state of Wisconsin, Brown County order for involuntary medication and treatment.
Is that for Taylor Schabusiness?
Yes,
Is that from 2021?
yes.
Do those documents indicate that she was mentally with that
Yes,
and that she was court ordered to take some medications?
exactly.
Are those documents that you reviewed as part of your evaluation in this case?
Yes.
Offer exhibits 2 and 3.
Any objection?
No.
2 and 3 will be received.
So, Dr. Litton, you can carry on. What other documents or things did you look at as part of your evaluation?
I reviewed the other evaluators in this case, their reports. And then the 2 inpatient psychiatric hospitalizations from Bellin here in Green Bay. I reviewed voluminous school records, which I don't often get in these cases, but the school records for Schabusiness covered kindergarten through 11th grade and all the behavior incidences. So I think that's about it. And then the Prevea, we've asked for those records, but they haven't been received yet.
Did you review Nicolay Psychiatric Center records from Brown County?
Yes,
Did you review the report from Dr. Christina Engine,
yes,
Dr. Tracy Lucetta,
yes,
Dr. Matthew T. Seipel,
yes,
Dr. Deborah Collins?
yes,
Those are all psychologists, correct?
yes, they are.
Did you also review the criminal complaints and police reports and other case materials?
Yes,
Were you able to, before I get into that, did you prepare 2 tables, so
I
to
did.
speak? Okay.
yes.
Can you tell me what the tables are?
The simpler table, 1 page, is Ms. Schabusiness's mental health history with just the names of the records, the date of the treatment, if it was known, her age at the time, and then the diagnosis, medications, and the conditions. So that was the 1 page. And then the other one was prepared by her school, and it reflects 6th grade through 11th grade, but this is just the table that the school had prepared. I had also, though, reviewed her kindergarten through 5th grade. So this table is 6th grade through 11th, but I also reviewed kindergarten through 5th grade too.
Okay. And you brought these tables here and provided them to me, correct?
Yes,
And they've been provided to the state?
I guess. I don't know. They provided to the state.
Yes, they were.
Okay, yes, yes.
Your Honor?
Yeah, you told me that.
Thank you. Can I approach, Your Honor?
You may.
Thank you. Exhibit 4 is being presented to you. Exhibit 5 is being presented to you. Could you comment on Exhibit 4 first, please?
Exhibit 4 is a 1-page table, Taylor Schabusiness mental health history, with the record, the information came from, the date, if it's known, of inpatient or jail records, her approximate ages, and then the conditions during that either psychiatric treatment or in jail, the conditions, if they did make any diagnosis of her, and then medications, if there were medications prescribed. So that's what Exhibit 4 is.
You take through that in a little bit more detail as to the treatments she received and the medications?
Yes. And from the age of about 7 through 14, she was treated, and again, I can't remember how the Prevea, here in Green Bay or this area. probably outpatient, so ages about 7 to 14, and we know the 14 is definite. She was seen for, and she was under psychiatric care and I believe therapy, I think, counseling, for attention deficit hyperactivity disorder, depression. And she was begun on Zoloft, an antidepressant, 2 to 3 weeks when she was 14 before the admission to Bellin. So that's on the next line. Bellin Health Psychiatric Center Adolescent Unit, was there for 3 days, 2012, age 14. From the medical records, the conditions that they saw, the psychiatrists, the mental health people at Bellin, a thought disturbance, hallucinations, delusions, suicidal, depression. She was initially diagnosed with bipolar 1, depression, severe, with psychosis. She was put on an antipsychotic medication, Seroquel, and they discontinued the Zoloft that she had been taking 2 to 3 days, or 2 to 3 weeks before the admission. And the reason they discontinued the antidepressant medication is sometimes it can trigger worse symptoms in a person with bipolar. When she was discharged after the 3 days, no longer suicidal, she was then diagnosed with a mood disorder, not otherwise specified, without psychosis, but still the psychiatrist noted there was still some paranoia. You want me to just continue?
Sure.
Okay. The next admission, psychiatric, was same facility, Bellin Health Psychiatric Center Adolescent Unit, inpatient. That was for 3 days, 2 years later in 2014. She was diagnosed with a mood disorder with prior history of psychosis. She had a history of diagnosis of mood disorder, suicidal, attention deficit hyperactivity disorder, history of hypomania, and marijuana use daily. She was prescribed medications to treat some medications, lithobid. They're to manage bipolar disorder. She was prescribed Abilify, which is an antipsychotic medication, and they stopped the Seroquel that she had been on since the age of 14. The next is St. Mary's Emergency Room. She was there for just a brief visit, the ER, March 22nd, 2021. She was 23 years old. She was observed to have hallucinations, paranoia, delusions, and she was using, or she had a history, but I think she was using at that time, marijuana, methamphetamine. Okay, so that was 1 day at the ER. Then, and I believe, if I have this right, I believe she was in jail for 2020 offenses, and I believe she went to the emergency room in 2021 from the jail because of the psychosis. Okay, then we have the Nicolay Psychiatric Center inpatient from March 22nd, 2021 until April 12th, 2021. At that time, she had a 6-month civil commitment with an order to treat, which was what those exhibits 2 and 4 were, I think. Okay, this was 2021 for 21 days. The records indicate bipolar disorder, substance use, hallucinations, delusional, paranoia. She was initially on Abilify that she had been prescribed since age 16. And again, she was 23 during the 21 day at 23 years old during the 21 days at Nicolay. So they kept her on, I believe they kept her on Abilify, an antipsychotic medication, but then put her on an injected to make it easier. So you get the injections of an antipsychotic, Aristada, I think Aristada, I can't pronounce it, Aristada. They put her on that, so she hoping that she'd be more compliant, easier. You go to the psychiatrist, get a shot. I don't remember if it's once a week. How some of them last a month, so I'm not sure about that one. And I think I said she was diagnosed with bipolar disorder, substance use, had hallucinations, delusional, paranoia. The last records were the jail, Brown County Jail mental health records. That was from a stay 3 months in 2020, June to September 2020. She was 22 years old, and that regarded 2020 offenses, criminal. She was noted to be suicidal, bizarre behaviors, hallucinations, and had used methamphetamine and heroin. Then, from the ages of 24 to 25, currently, records from the jail were from January 4th, 2022 to July 9th, 2023. She had, and I'm getting these from their mental health records, psychiatrists, mental health people at the jail. They noted she had suicidal ideation, bizarre, self-injurious behaviors, many conduct reports. She was nonverbal and isolative in her cell at times. She smeared and drew on her cell walls with feces and menstrual blood. She was naked at times. She had hallucinations, intense anger at times. She was prescribed Risperdal, an antipsychotic medication for, quote, psychosis and impulse control, but she was usually non-compliant. Then as far as I know, the antipsychotic olanzapine is currently her medication prescribed at the jail, but she is typically been non-compliant with taking it. And that's it for that exhibit.
Did you generate a report in this particular case?
Yes.
Time off for, one, two, three, and four.
Some of them have already been admitted. Assuming the only one that hasn't been admitted is 4. Any objection?
No.
4 be received.
Thank you, R. Dr. Litton, you prepared a written report, correct?
Yes.
And was that dated July 3rd of 2023?
Yes.
Was it 15 pages?
About that, yes.
Did you sign it?
Yes. Oh, 9 pages.
You did review her medical and mental health history, correct?
Yes.
Her background, correct?
Yes.
Her family and social background, is that fair?
Yes.
Alcohol, drug abuse, and education?
Yes.
Sexual, physical abuse history, fair?
Yeah. Yes.
Jobs,
Yes.
charges?
Yes.
Tell me about the first interview that you did with her.
That took place February 7th, 2 attempted interviews, February 7th, 2023, at the jail in a conference room. She remained nonverbal the entire time I attempted to interview her, and she suddenly ran to the corner of the room, picked up a plastic chair and threw it at me. I called the guards. Took them a couple minutes to get there. She sat down, I sat down, tried to calmly ask her why she threw the chair. She, again, was nonverbal. The guards came. I explained the situation. They initially said, yes, I should terminate the interview, but offered the possibility of taking Ms. Schabusiness to a secure booth to see if she'd interview. She nodded that she would be willing to go there and talk to me. We got there and she again was nonverbal. That was the first 2 attempted interviews, February 7th, 2023.
So you had 2 interviews with her on that day.
2 on that day.
The one interview, was that in a room with just you and her and a table?
Yeah, yes.
And in that interview room, they have a stack of chairs there?
1 chair in the corner.
Okay. And then later you went to a more secure area where there was glass. Did you talk to her there?
I tried to, and she again was nonverbal.
That was before I got involved. Is that fair?
Exactly.
Then did you have the occasion to meet with her on a different date?
I did when the last attorney, the original attorney on case, after she threw the chair at me, was nonverbal on February 7th, 2023. Her defense attorney went, like the next day, went to discuss things about, why did you throw the chair? She didn't have an explanation. But she agreed, and she was verbal to the defense attorney. She told him, yes, she would then interview with me. He said, I'll come back tomorrow to double check. He returned, I guess, the next day. She again said she was verbal with him and agreed that she'd interview with me. So I returned on February 13th, 2023, and she refused to even come to the interview room. So those were the first 3 attempted interviews.
Was there an occasion where you had another interview with her?
I did, yes.
When was that?
On June 19th, 2023,
At the Brown County Jail,
yes.
in the interview room?
In the conference room, yes.
And what is the conference room? Can you describe the layout there?
Not a huge room, but there's a table, a bigger table in the middle, and plastic chairs, thank goodness, plastic chairs. And then there was that the people sit on. And then, one plastic chair in the corner, not a huge conference room.
From the incident on February 7th where the chair was thrown at you, did you have some safety concerns, precautions?
With her or me? Or,
Yes.
she was handcuffed to a waist belt.
But I mean, did you have concerns from the incident on February 7th where the chair was thrown at you?
Oh, yeah, definitely.
Okay.
First time in 32 years, a chair's anybody I've interviewed ever did that.
So on June 19th of 2023, you had another interview with her.
Yes.
Did you make any requests at all?
Well, for you to be there, but you had already met with her several times. She had not been aggressive with you. Ideally, I wanted to meet with her in that conference room as opposed to behind plexiglass in a little tiny booth. So yeah, the June 19th, 2023 interview, she did talk, was in that conference room.
You asked me to sit.
Yes, I did.
Did I interfere in any way?
No.
And so tell me a little bit about that interview on June 19th of 2023.
We only, I was only with her for 2 hours. She had a great deal of trouble, difficulty with paying attention and concentrating. My impression of her at that 2-hour interview was she was psychotic. She had visual, auditory, hearing, visual hallucinations, auditory hallucinations. She was delusional. She was paranoid. She answered some of the questions. My impression of her was that she was really trying to answer questions, and she was verbal. This time she spoke with me. She was verbal, but my impression was that she was really trying to answer my questions. But her thinking was very, what we call disorganized, very delusional. She was actively hallucinating, hearing things, a train, a loud train whistle that she screaming, which she told me she hears in the courtroom too. As the 2 hours went on, she became so distracted and very, afraid. You could see it on her face, fear, because of the delusions she was experiencing right then. She got more and more scared about what she thought she saw, a train, and of this louder whistle, So after 2 hours, that was it. She was so, in my impression was that she was so distressed. I didn't want to continue the interview. I felt I would be inflicting more harm on her if I continued the interview. So she gave me some information about her bipolar condition, her mental health history, family. Yeah, that
Doc-
was.
Dr. Litton, thank you. Do you have an opinion on whether or not Ms. Schabusiness's memory for remote or recent events was impaired when you were there?
Yes.
Tell me about that a little bit.
Not only did I see that memory issues, impairment in the 2 hour interview, but I see it in her records too. She can sometimes remember remote events, like, pretty well, where she lived, approximate dates, the approximate time her mother died, and so the date when she got married, roughly. It's a little fuzzy, but yeah, better remote memory. But she often will, in the same interview with treaters, evaluators, she'll be confused. And I saw memory impairments during the 2 hours, memory gaps, kind of a person with bipolar disorder or other psychotic disorder like schizophrenia. When they're actively psychotic, we sometimes see memory gaps for the time they were very psychotic or bipolar 1 disorder. When they're in a manic state, they can often forget what's going on. Then when they come out of the psychosis, sometimes they'll have a spotty memory. Sometimes the whole memory will come back of what they were doing, what happened during the psychotic episode. But sometimes it's totally blank. Sometimes it comes partially back. And sometimes they try to reconstruct what happened, and you get a kind of a funny reconstruction. How do they explain their behavior when they were manic with bipolar or psychotic from schizophrenia, for example? They'll do a funny, not funny, haha, but bizarre reconstruction. Well, let's see, if I did that, if I got married while I was psychotic, well, let's see, I must have liked the guy. Or I've heard some really odd memory issues.
What about her speech? Can you give me any commentary on her speech from the observations you made?
Her speech is generally, you can understand, I could understand her. She generally speaks in what we call connected sentences. So you can understand her speech. She's not, there's another term, word salad, for somebody who's psychotic, who just blah, blah, you can't understand, called word salad. I've never, in her records, and when I interviewed her, she's never been like that. So you can understand her speech, and she'll speak in brief, we call connected sentences. Sometimes they're logical, lucid, but other times not. They don't make sense. They're going off track. They're, whatever we're talking about, poof, she goes off track.
Are you saying goes off on tangents?
Very much so, yes. Not always, but yes, I observe that in the records too.
When you discuss certain topics, is she connected or disconnected?
Sometimes, like in the 2 hour interview, sometimes and again, my impression was that she tried really hard to answer my questions. Sometimes she was connected to what I was saying and to reality. Other times, no, definitely not connected in my impression.
During the 2 hour interview that you had with her on June 19th, Was she distracted by any internal or external stimuli?
Yes.
Tell me a little bit more about that.
She was distracted by a clock on the, and this is one of these tangents, a clock on the conference room wall. She was distracted by a cord. We had just been talking about past suicide attempts, and she had tried apparently to hang herself when she was a teenager or younger. Cord, and a voice telling her to hang herself with that cord, but she said, I'm controlling it though. She had a train. She thought she saw a train and a whistle that got louder and louder and louder. She was delusional in her thinking. So those are just some examples.
Did you ask her about her mood on a scale of 1 to 10?
I did.
And what was the response you got?
007, which was bizarre. And I think a reference to James Bond.
What could you take from that?
My impression was that, again, it was some tangent. And, it sounds pretty goofy, bizarre. I asked her to clarify that, and she really didn't. It led into a discussion of mania, bipolar 1 mania, and we discussed that, her impressions of bipolar, and has she ever had a manic episode?
Is obsessive compulsive disorder a mental disorder or issue?
Is it for her or just in general?
Just in general.
Yes, it's a mental disorder.
Did you talk to her about any compulsive behaviors or any issues like that?
Yes.
Tell me about that.
I brought up the issue of hypersexuality, also just obsessive compulsive symptoms, traits. And she said sometimes she's will touch her hair a lot. She'll wash her hands 30 to 40 times with germs. But then I asked her about hypersexuality, which is sometimes seen in a person with bipolar 1 disorder when they're in a manic state, manic psychotic state, this hyper, too much interest, arousal with regarding something sexual. And she was very surprised. She had never heard of that. But she clicked on it. It was interesting. She clicked on it like, oh, and then she described some past obsessiveness. And I think she said in 2020 for about a year when she and her husband viewed a lot, and she called it, obsessive, adult pornography.
Does hypersexuality give you concern or pause as it relates to mental health issues?
It does, because, and this wasn't the additional evidence about it, that she has likely, well, in my opinion, she has had hypersexuality during the bipolar disorder, when she was diagnosed at least age 14, but probably before that. She made inappropriate sexual comments in her classrooms while growing up at school. Then when she was inpatient, I believe the 21 days, I think it was Nicolay, and was it 2021, she was inappropriate. They caught her in the bathroom, 2 separate incidences with a male, 2 different male patients. And I think there's been some incidences in the jail. I don't remember that exactly. But yes, that's definitely a concern. I've seen other people with inpatient, outpatient, who are hypersexual and again associated with bipolar mania, manic episode, or could be schizophrenia, but typically bipolar disorder. I've certainly seen that at Mendota and when I treated or evaluated people. It's not incredibly common, but it's one of the classic symptoms of a bipolar manic episode.
Did Ms. Schabusiness say anything about her thinking and her feelings on that?
Yes.
What did she talk to you about?
You mean during that 2-hour interview?
Yes.
Yeah, and I'd have to look at the exact quotes here, but the thinking, she hears screaming in the courtroom. It sounds like quite constant, she said. I'm looking here. Yeah, she said she reported she hears screaming all day long, and not from the other jail inmates, telling her to wake up. Screaming happens, quote, a lot when she goes to court. It, quote, very much so, end of quote, affects her ability to concentrate on a daily basis and when in the courtroom. And then the voices, the screaming, are scary and tell her to do stuff. So her thinking I always ask people I evaluate, how is your thinking and memory? And to me, it's just the thinking it's difficult for her to think because of the bipolar symptoms of psychosis thinking. It affects her attention and her concentration and messes up her thinking. Difficult.
As part of your complete analysis in this case, did you find that Taylor Schabusiness is married?
Yes.
And did she provide you with any information about the marital relationship?
Yes.
What did she say about that?
She said that, I hate to say this about someone not here, but she said that her spouse, who I believe they married in 2020, got her involved in methamphetamine use. He was a dealer. He was, again, her reports about this vary, but she has reported that he was very physically abusive, hit her. Well, she told me that he hit her on the head numerous times. That was when I was evaluating her, any head injuries ever in your past. And she mentioned that he had hit her on the head numerous times. So very controlling person. And she had gone to a neighbor's house at one time in 2020 to ask them to call 911. And another neighbor, when the police came, another neighbor said that she knew them both. And she said, yeah, he was abusive, controlling, drug pusher, addict. Yeah. But she is still married. I believe but she was going to, in 2020, she was going to try to get the marriage annulled, but I don't think that's happened at this point.
While you're changing topics, I think we'll take our mid-morning break. We started a little bit later, but it's 10:45 right now, folks. We've been going for about an hour and a half. We'll take about a 10-minute break. So all rise for adjournment. anything before we recess? Mr. Saunders?
No, thank you.
Mr. Fairley?
No, thank you.
All right, and let's reconvene at 11 o'clock. We're in recess.
Thank you.
Hey, be seated. All right, we're back on the record. Mr. Freilich, the witness is yours.
Thank you, Art. Based on your review of the educational records for Taylor Schabusiness, did you make any conclusions about whether she had a budding personality disorder?
No, I did not. No.
Did you see in the records that she was a really disturbed teen?
Yes, that was my impression.
And did you indicate that you felt that it even went beyond that?
Yes. Which was later confirmed when we later received the Bellin inpatient records from when she was 12 and then again at 14, and was diagnosed with a thought disturbance, bipolar 1, depression, severe with psychosis by age 14.
Did you have a chance to review a colleague's evaluation, Dr. Tracy Lucetta?
Yes,
Is she a PhD?
she has a PhD.
And she reviewed or examined Taylor Schabusiness in the past, correct?
Yes,
So you had a chance to consider her report, correct?
yes,
Did you also review Dr. Matthew Seipel's report?
yes,
And he's a forensic psychologist from the Wisconsin Forensic Unit, correct?
yes,
And then did you also have the opportunity to review Dr. Christina Engine's report?
yes,
And these are reports that were conducted based off evaluations of Taylor Schabusiness, correct?
yes.
Before I ask you about whether you agree with their opinions or not, I'm going to ask you about what is your opinion as it relates to your evaluation and assessment of Taylor Schabusiness?
My opinion is that she qualifies for the not guilty by reason of mental disease or defect. My opinions are that she was not responsible because of a mental disease. She wasn't responsible for the criminal conduct because at the time of the event, she had the mental disease, and it both affected, she lacked substantial capacity to both appreciate the wrongfulness of her conduct at the time the homicide occurred, but also she could not conduct, she couldn't conform. She lacked volitional control. She couldn't conform her conduct to the requirements of law. She was lacking in her ability to control herself. The volitional control both was lacking. That's my opinion.
You said that she lacked the ability to control herself?
Yes, at the time of the event.
And do you opine that she has a mental disease or a mental defect or both?
Yes.
Both?
It's unclear. I tried to get her to be evaluated. I suggested she be evaluated, as Dr. Lucetta did too, further for possible defect, mental defect, brain issues. That didn't happen. But my impression was that she has a mental disease, which is the most likely bipolar disorder.
Based on your training and experience, can chemicals exacerbate?
They can, yes.
Did you draw any conclusions on whether Taylor Schabusiness has any kind of chronic brain damage?
I couldn't because that has to be done. For the first step is what we call neuropsychological testing by a neuropsychologist. Pretty elaborate testing. That's the process. And then if those test results are abnormal, then the next step would be a referral to a neurologist and medical doctor who would assess her and then decide whether or not there was enough information from the testing to explore the possibility of some brain defect, brain damage, maybe, yeah.
Okay. In your report, your opinions are on the last page. Is that fair?
Yes.
And did you talk about her presentation when she presents herself? Do you have comments about that?
Yes, it's my comments about that are that it's very, a very, very unusual, what we call presentation. How is she looking? How does she talk? How does she interact? Everything, what's going on in her mind, whatnot. And it's really, really unusual. And I searched my own 32-year memory bank here. And it's exceptionally unusual presentation, how she's coming across to me, the two attorneys, other evaluators in the school.
Would you agree that she has a strange presentation?
She does.
How about her facial expressions? Can you give some commentary on that from what you've seen?
Very unusual. She's been described as smirky. Smirky. She has inappropriate, her, grinning, weird grinning when she's talking about the crimes. People have interpreted it to be like laughing at what she did. At times, in the jail, with evaluators, with me, at times, briefly, it's very strange. Other times looking, I can mimic it, very scowly. A lot of people interpret it superficially to be grinning. Grinning at all, but getting a kick out of everything. Nah, not me. Based on my experience and training, that's a psychotic person right there. That's what's causing this really weird, bizarre. And I'm telling you, to me, it's off the scale. 32 years. I've seen a lot of psychotic people, bipolar, psychotic, manic, and I just haven't seen very many like this. That is very exceptional, very exceptional.
Do you believe that she has a genuine mental disorder
Yes,
of a psychotic nature?
yes.
What is the nature?
The best, my best opinion is the bipolar 1, with sometimes with psychosis, sometimes not. But that after we got the Bellin records from 2 inpatient admissions at age 12 and 14, or 14 and 16, let me just double check. Yeah, 14 and 16, she was diagnosed at 14 with bipolar depression, severe with psychosis. So that confirmed that's I was thinking about schizophrenia, and sometimes schizophrenia and bipolar are very hard to distinguish. Sometimes not, but sometimes really hard to tell bipolar from schizophrenia. And there's a kind of a combined one called schizoaffective disorder, and that that's been applied to her too. But I think based on this history we have from Belen when she was diagnosed with bipolar, and then again at Nicolay when she was 22 years old, also bipolar. Yeah, my opinion is based on my experience and training is bipolar 1. The more serious, there's bipolar 1, bipolar 2. But bipolar 1 can have psychosis, psychotic episodes. So that's my opinion.
Are your opinions to a reasonable degree of professional certainty or psychological certainty?
Yes,
Both, correct?
yes.
You did prepare a report on all of these findings, correct?
Yes.
Could I approach your honor?
You may.
Exhibit 6, did you identify what that is?
That is my report, July 3rd, 2023.
Does that report contain all of your findings and evaluations based on Taylor Schabusiness?
It's a brief summary, yes.
Everything in there is accurate, correct?
I hope so. Yes, I think so.
And the report is dated July 3rd of 2023, correct?
Yes.
Offer Exhibit 6.
Any objection?
No.
6 is received.
Doctor, you did review Dr. Matthew Seipel's report, correct?
I did two reports.
Okay, you read through both of them?
Yes.
You're aware of the opinions and findings that he rendered, correct?
Yes.
Do you agree or disagree?
Disagree.
Tell me why.
Contrary to how Dr. Seipel, his opinion, which I respect all professionals' opinions. I don't criticize the professional. I can support my own opinion. But in contrast, I believe that she has, my opinion is that she has a genuine mental disorder.
And then Dr. Christina Engine, did you review her evaluation?
Yes.
And you agree or disagree with hers?
Disagree.
Tell me why.
Similar to Dr. Seipel, if I remember her report well enough, I disagree. My opinion is that Ms. Schabusiness has a genuine mental disorder of a psychotic nature.
Okay, I have no other questions. Thank you.
Cross-examination.
Good morning, doctor.
Hi.
Sorry, I'm a little hidden here behind the court reporter, so I'll try to move over. Can you hear me okay?
Oh, yes.
Okay. So you testified you're an independent forensic psychologist, is that right?
That's right.
And does that mean that you're just sort of a solo practitioner, you're not employed with a larger facility?
Right. I don't work for anybody. I work for myself.
And you've been retained by the defense in this case?
Yes.
All right. So is there a retainer agreement in place?
No, say the very vast majority of my cases were for the public defender. So they have an appointment letter, how much they think they're going to pay, like that.
Okay.
No money up front until the case is done and I bill,
I understand.
or he bills.
Sure. But you are being obviously compensated for your testimony.
No, I haven't been paid anything. No, I've been on this case, since 20, I don't get paid till the case is all done.
Okay. But at the end of the case, you will.
Right.
Okay. You were asked questions about having previously conducted NGI evaluations in the past.
Right.
How many?
Hundreds? I don't know. Maybe, a lot.
All right. And how many in the last 10 years?
Many. And I have several right now. Many.
Okay. So like dozens?
Oh, yes, at least. Yeah.
And your CV, do you still have that in front of you? I believe it's Exhibit
No.
1. You outlined some on page 2 publications and presentations that you've completed. Is that right?
Yes.
And for instance, in 2022, you had a publication or presentation on sexually violent persons.
Yes.
And similarly, in 2001, another publication on sexually violent persons.
Those were presentations. Yes.
And would it be fair to say, I mean, looking through 2009 at least, all the publications and presentations we're seeing are with respect to sexually violent persons cases?
Most
Okay.
are, yes.
And do you have publications or have you presented on the topic of conducting NGI evaluations?
No. Other than 2018, a young colleague and I did a fill-in at the Wisconsin Psychological Association just on starting a forensic practice. And, we talked about the different kinds of it. Like, it was to a group of psychologists who were thinking of getting to be a forensic psychologist. So we probably mentioned NGIs.
That wasn't like a presentation on how to do NGI
No,
evaluations?
no.
Okay. I then want to ask about some of your sources of information, and council went through some of those with you. With respect to what occurred on February 22nd, 2022, what sort of information did you review?
The criminal complaint. You said what information did I review regarding that
Yes.
event?
Yes.
Okay. Yeah, because nobody was there. Parents were upstairs. So we don't have any direct witnesses, but I reviewed the police reports, all their interviews. That's basically it. What she told other evaluators and what she told me very briefly. So that was it.
So it was when you say police reports, you're referring to like the paper report that a detective or officer wrote?
Right. There's the criminal complaint or information, which is a couple pages long, but then attached usually with it, are the basis for the criminal charges. And, with the police, I guess in this case, the police who went there, arrested her, their interviews with her.
So did you just review the criminal complaint or also all of the police reports? in
All
case?
the police
Okay.
reports.
So then it sounds like you didn't review the recorded interview itself of Schabusiness.
Transcript, the recorded interview herself, and at least an hour and a half, 2 hours of the video interview.
I'm sorry. Did you review the recorded interview of Schabusiness from February 23rd of 2022?
What I was given by the attorney was a transcript of their interviews. And so a transcript, written type,
Okay.
the transcript.
Was it like the police report summarizing it?
If I remember right, it was a transcript of I don't know if they had a court reporter in there. I don't know how they do that.
But not the actual visual image itself. You didn't review
I only saw about an hour and a half, 2 hours of the visual, whatever you call that, video in those conference rooms where the police detectives were interviewing Ms. Schabusiness.
So you reviewed an hour and a half of that. Was that the February 23rd interview?
Yes, I believe so.
And so you didn't review the rest of the approximate 5.5 hours of that interview?
No, it didn't transmit to me by computer for some reason. So it was only roughly an hour and a half, 2 hours of what I did see.
I guess the defense didn't provide the whole interview for you?
They tried, but for whatever reason, I don't know, technology between the DAs or what, that's happened before, not uncommon.
Sure. Well, to be clear, we aren't providing you any information to review, right?
What, pardon?
The state isn't providing you any information to review, right? You're getting that information from other people.
Well, I think it goes from you all to him.
Sure.
Yeah, right, and then to
Okay.
me, yeah.
So then it also sounds like, Doctor, you haven't reviewed the February 28th interview of Schabusiness?
I read the police descriptions of it, and I thought I had a transcript. I think it was a summary, pretty decent summary of the February 28th. Similar, the summary, pretty decent, detailed of the February 23, the 2 interviews they did on that day.
But not, again, the actual visual image, the recorded interview itself.
Not from that one again. If it was sent to me, I couldn't see it.
And You mentioned that obviously one of your sources of information is from your meeting or meetings with Ms. Schabusiness.
Yes.
All right. And the June, scratch that, the February 7th, 2023 interview, that was the instance where Ms. Schabusiness threw a chair at you, right?
Yes.
And after she did that, you said she just sat down.
Yeah.
All right. And was calm after that point?
Very. And I looked at her, as I subject to doing, I used that time before the guards came in. Maybe it took a while, 3 minutes or so. And it was weird, bizarre, whatever you want to call it, because she immediately, very calmly, came back, sat down across from me, and I looked at her physiological responses, just totally blank. And again, I've seen violent patients. I got attacked once, and beat up at Mendota, got slapped. But I saw very many aggressions on the unit I was on at Mendota for the 14 most aggressive patients, males in the whole state. And we'd have between 3 to 7 aggressions. And usually after a person does something like that, they have a red face, angry, yelling, swearing, breathing heavily, nothing.
So, those prior instances you talked about, those were with people who were at Mendota, you said?
Yeah.
So those were people who were actually found to have a mental illness.
No, not all of them. We were the overflow unit. We mostly had our patients were from around the state, jails, prisons, Winnebago mental health. They were most of them had been found not guilty, legally insane. But we were the overflow unit for the admission unit for competency evaluation. So they were not all necessarily mentally ill, but most were with a psychotic illness.
And those were the people who kind of made a gesture like a red face,
Yeah,
things like
but
that after.
I've dealt with many aggressive people in the outpatient setting too. And yeah, it was unusual. I just don't, searching my memory banks, had a hard time coming up with somebody, I've seen it before, but it's unusual for a person to not be aroused, when they're feeling so angry. It was unusual.
And then I want to ask about the June 19th, 2023 interview with Ms. Schabusiness. And that was at the a conference room area,
Yes.
and her attorney was present for that, right?
Yes.
And is it common for you to have those sort of evaluations with an interested party in the room?
I always ask attorneys, going back to when I was at Mendota, I learned this at Mendota. I always ask attorneys if they have the time to sit in at least during the initial part, like for a competency evaluation, so I can see the attorney and the client interacting. And so it gives me more information about whether the defendant is understanding what's going on, if they're able to work with their attorney. So I always ask attorneys to do that. Sometimes they do, sometimes they don't have time, whatever. It was unusual though, in this case, that the defense attorney sat in through the whole thing. I did it for a particular reason though.
Okay. And then you talked about exhibit number 4. Do you still have that in front of you, Doctor? It's the chart you prepared.
Oh, sure. Yeah, right.
Okay. I know there's a number of exhibits here. So you kind of listed the age of Ms. Schabusiness at the time of various admissions. Is that right?
Right, approximate age.
So it looks like ages 14, there was a Bellin Health Psychiatric Center.
Yes,
Age 16 from Bellin Health Psychiatric.
yes,
And then there was nothing that was reviewed until Ms. Schabusiness was 23.
right.
So you reviewed no mental health history, and you're aware of no mental health history from ages 16 through 23.
Well, 2020, she was in the jail. Or no, I guess that was 2020 when she was 22. So yeah, no, there's a gap. Yeah,
So there wasn't anything, I guess, from 16 to 22 then?
not that I know of.
And when you were kind of summarizing the chart in Exhibit 4, I noticed a few times that when you were describing hallucinations, there was also sometimes then concurrently reports of methamphetamine use. Is that fair?
Yes.
And in your experience, methamphetamine can produce psychosis as a side effect.
Yes, it can in some cases.
And that was actually reported in quite a few of these records, wasn't it?
It was.
So then I want to ask about the Bellin stay in 2012. You reviewed those records, right?
Yes.
Okay. And in particular, did you review the discharge summary?
Yes.
And I guess the discharge summary, that's kind of like the exit interview, so to speak. Right?
Exactly.
All right. So you would recognize that if you were to see it?
Maybe. But I have it on the chart. I believe at the discharge, she was diagnosed with mood disorder, not otherwise specified, without psychosis by the 3 days.
Okay. And that's exactly right, doctor. So I'm going to show you Exhibit 7. Does that appear to be the discharge summary we're talking about?
Yes.
And in discharge diagnoses, you mentioned a mood disorder without psychosis.
Yes.
Nowhere in the discharge diagnosis is there a bipolar diagnosis, is there?
Yes, that's true.
And in fact, if you could flip to the last page of that, it says page 118 on the bottom, but it's the last page of that stapled packet, doctor. You see the portion that says condition on discharge?
Yes.
Okay, and it says, quote, on exam, Taylor denied hallucinations or thoughts of harm toward herself or others, a wish to be dead, or that she would be better off dead. Did I state that accurately?
Yes.
And that was the Bellin health records from 2012.
Yes.
I then want to ask about the Bellin health records from 2014. You reviewed those as well?
Yes.
And there was a portion that contained the discharge notes as well. Is that right?
Yes.
All right. Okay, I'm going to show you Exhibit 8, doctor. Do you recognize that?
Yes.
Does that appear to be some of the discharge notes from October 29th of 2014?
This was difficult because you see at the top and all through here, pretty weird because it's got every page at the top says 10/28/2014 admission and then parentheses discharged from assess at Bellin. So it's confusing. It was one of the more confusing medical. I've been reviewing medical records since I was age 14 as a candy striper, and this was hard. So it's difficult to figure out, is this the final discharge? And I think I finally concluded is she was only there for 3 days, so I think it's the discharge, but it's the discharge summary, but it is confusing. You have to look at all the dates and everything, but this was really confusing.
Sure. But if you could, doctor, flip to the last page of that exhibit. Do you see the area where it lists the diagnosis for
Yes.
Schabusiness? And there's 2 diagnoses, aren't there?
Right,
One of which is cannabis abuse, continuous.
right.
The other is alcohol abuse, episodic.
Yes.
Okay, there's not a bipolar diagnosis listed there, is there?
No, there's not.
There's not that prior mood disorder that we heard about in 2012, is there?
Somewhere in these pages, I believe that
And I'm sorry, doctor, if the question
Okay.
is clear, in the diagnosis part, neither of those diagnoses are listed, are they?
exactly no bipolar, and what else was the other thing you said? Mood
The
disorder.
mood disorder.
Yes, you're right.
And that was the Bellin from 2012, right?
Yes, age 16.
I then want to ask about these records from Nicolay Psychiatric, and that's sort of the county admission, right, to locked facility?
Yes.
Okay, and actually the St. Mary's hospital visit you testified to on direct, that was like the day before the admission to the Nicolay Center, right?
I think it was the day of. I
Okay.
think that it looks like, because it's March 22nd, 2021. I think St. Mary's ER discharged her right to Nicolay. I think that's how that went down.
Okay. So when Ms. Schabusiness was admitted into Nicolay, she had a drug screen done, did she not?
Yes,
And that drug screen was positive for controlled substance, was it not?
I believe so. I don't have it written down here, but substance use, yes. And then by then, my memory is that it was meth, I think, probably THC, marijuana.
And Doctor, you had reviewed those records from Nicolay Psychiatric, right?
Yes.
And those helped you reach your conclusion?
Yes.
All right. So I'm going to show you Exhibit 9. Now I didn't mean to test your memory. I know you reviewed a lot of records. So does that appear to be the notes from Ms. Schabusiness's admission into Nicolay Psychiatric?
Yes.
And that's dated March 22nd of 2021.
Did you say 27th? It's 23rd.
March 20, you're correct. The admission date is March 22nd.
Yes.
Okay, and the date of service that's listed here is March 23rd.
Right.
And then in the history of present illness, it states in the second line, she has been using methamphetamine. She would not tell me how often and how much she has been using it, but drug screen was positive for methamphetamine, amphetamine, and THC. Did I state that accurately?
Yes.
All right. And then Nicolay Psychiatric, that's a sort of locked facility, right?
That's my understanding is it is. I don't think I've ever been there, but my understanding is it's probably locked, I would guess.
Is it a facility that's sort of closely monitored? And
Yes. I think they do. I think I did read that they lock their units, I believe.
I guess the purpose of all that staff presumably is to watch after patients.
Well, right, because she was there on a mental health commitment, so she either had to have been dangerous to herself or to somebody else, and those are usually locked units.
So presumably, people who are in that facility aren't, using controlled substances anymore.
Usually.
Usually. So then I'm going to show you exhibit number 10. Does that appear to be the discharge notes from Nicolay Psychiatric?
Yes, this one we know because it says final summary on the top.
And that date is April 12th of 2021.
Yes.
And there still is for the discharge diagnosis, as you mentioned, a bipolar diagnosis, right?
Yes.
Can you flip to the second page? On condition on discharge, it states the patient has a bright affect. Is that right?
Yes.
That she is forward looking.
Yes.
that she showed some motivation regarding remaining clean and sober,
Yes,
that she denies any delusional beliefs,
yes,
that she, I guess it notes, there's still some degree of paranoia is present, but denies any thoughts of self-harm.
yes.
And that was after being in that facility for that time.
And she was just she was on oral antipsychotic, but she just was started on the injected medicine, the longer acting injected antipsychotic. It's called atypical antipsychotic medication, which then she didn't stay on after the 6-month order to treat.
But also on April 12th, she presumably would have been free from methamphetamine, amphetamine, and THC.
From so 21 days, usually in general, it would have been out of her system, but it could be still possibly affecting her thought processes. You just don't know because the testing wasn't done.
Sure.
But no, but totally, yeah. She still had some paranoia. It says some degree of paranoia was still there. However, she wasn't no delusional beliefs. So she wasn't super psychotic. Wasn't psychotic.
And actually, I glossed over two discharge diagnoses. One was the bipolar, right?
Yes.
Well, there was a second one, wasn't there?
Yes. Substance use disorder, i.e., in other words, THC, marijuana, and methamphetamine.
Thank you. You talked then about some of these hallucinations that are scattered throughout the records you reviewed, right?
Yes.
And some of those are things that the defendant is endorsing. Isn't that fair?
Yes.
And what does endorsing mean?
She's saying self-report. She's reporting them herself. She's describing some of them herself. Not a lot over her history. Are you talking about the hallucinations?
Just the concept of what endorsing means. And I
Yeah,
think you stated
that's
it.
just
Something
saying.
that's reported by a person.
Do you have a headache? And if you say yes, that you're endorsing the headache.
Thank you. And actually, while we're still on the topic of the bipolar diagnosis at Nicolay Psychiatric, you mentioned that you reviewed a report authored by Dr. Lucetta. Is that right?
Yes.
And Dr. Lucetta was a expert retained by the defense earlier in the case.
Yes.
And she prepared a report that you reviewed.
Yes.
And part of that report, Dr. Lucetta spoke with Ms. Schabusiness.
Yes.
And do you recall a portion where they were discussing that bipolar diagnosis?
I don't remember that exactly.
Would it
I'd have
assist
to look at it.
Would it assist to review
Sure.
Dr. Lucetta's report? Okay, I'm going to show you what's been marked as exhibit number 11. Does that appear to be consistent with Dr. Lucetta's report?
I believe so.
Can you reviewed that report?
Yes.
Doctor, if you could turn to page 3 of that report. In the second paragraph, I guess it's the first full paragraph. Sort of the last sentence of that. In his quote, she, and that refers to Schabusiness, questioned the bipolar diagnosis, hypothesizing that her symptoms were attributable to methamphetamine abuse, explaining that prior to admission, she had been administering the drug intravenously up to 9 times per day for 5 to 8 months prior to her admission. Did I read that right?
Yes.
And that's referencing the Nicolay records that we just talked about, right?
Yes.
And that's where the bipolar diagnosis came from.
Just a second here. She seems to be, at the right beginning, it says Miss Schabusiness reported that she was previously admitted, blah, 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 blah. And it seems like that's what she's telling to Dr. Lucetta. But then at the point where that last sentence, she questioned the bipolar. That's, and I remember reading this and I couldn't quite figure it out. I think you're right that when she questioned the bipolar diagnosis, attributing it maybe to methamphetamine abuse. I think Dr. Luchetta is taking that Miss Schabusiness, that's what she told Nicolay, the psychiatric staff there, I think.
That your interpretation is that sentence refers to what Ms. Schabusiness told Nicolay?
Well, Miss Schabusiness told Dr. Luchetta at the beginning of the graph, she admitted Nicolay. Okay, so that's her self-report. She was vague about why admitted bipolar. She was diagnosed with bipolar. She was discharged. She discontinued the medication. She doesn't like to take medication. She questioned the bipolar diagnosis. So I'm not sure if that reflects when she was at Nicolay or what she's telling Dr. Luchetta. I'll go, and you think it was Dr. Luchetta. So that's okay because she's done that. Sometimes she'll say, this is Miss Schabusiness, yeah, I've been diagnosed with bipolar. Other times she will say, I don't think I've got it. I don't like to take medications. It varies. It does vary. So let's just agree that this is what she's telling Dr. Luchetta, but it's a little hazy there.
And I guess the point, doctor, in any event, the sentence I read, those were the statements of Ms. Schabusiness regarding the bipolar diagnosis.
Right, regardless if she's telling Dr. Luchetta or the treaters at Nicolay. She questioned it. Not unusual.
Sure. I then, doctor, would like to talk a little bit more about bipolar 1. What is the diagnostic criteria for bipolar 1?
Ugh. When a person has a definition, they have to have had at least one what's called a manic episode, which is extremely elevated mood. And it can be with psychosis, thought disorder, or not. But they have to have at least one prior or current manic episode. I pull by two things. It's either you go from depression, really bad depression with bipolar 1, super duper suicidal type, real depression, and then they have to have it in their history. So one of the real super duper elevated moods, and it's bizarre when you see it. It's pretty bizarre. Yeah, so that's basically it.
So you need at least one manic episode.
Yes, I believe that's in the diagnosis.
And in order to diagnose a manic episode, there are 4 criteria, aren't there?
We look at the mood, a very elevated, exceptionally elevated mood, and then usually there's these other behaviors that go along with it. Again, the person can be psychotic, not necessarily, but they can be psychotic in this very elevated mood. And then they usually are some other behaviors. They can stay up for 3-4 days. They wildly spend, sometimes gamble away, hypersexual, energy, feeling super energetic.
So there are 4 criteria, right?
Yeah. I don't have my DSM book in front of me, but
So the DSM-5 that you referenced, what is that?
that's the American Psychiatric MD's Psychiatric Association Diagnostic and Statistical Manual, the 5th edition. I think out in about 2015, I think it was put out and it's used in this country for mental health diagnoses and billing.
You would agree it's a pretty commonly used and widely accepted
in the
source.
United States, yes.
So for a bipolar 1 diagnosis, the first criteria is that there's a distinct period of abnormally and persistently elevated behavior. Is that fair?
Yes.
And that period has to last, quote, at least 1 week and present most of the day, nearly every day. Does that sound right?
Yes.
So it's not just a manic episode that is an hour, right? It's a long period of time that somebody's manic
Right.
in a heightened state. Is that fair?
Yes, yes,
And then the second criteria is some of those, symptoms, mood disturbances. You mentioned gambling, things like that are exhibited.
yes.
And that mood disturbance, the third criteria, also has to cause an impairment of some kind, right?
A what?
An impairment of some kind?
Yes, an impairment, yes.
And then the fourth criteria for a bipolar 1 diagnosis is that the manic episode is not attributable to the physiological effects of a substance,
Yes,
i.e. a drug,
yes,
such as methamphetamine.
exactly.
So,
Or
Even-
LSD,
sure.
something.
So if you're observing a manic episode, but you have information that there was recent methamphetamine use, that would be a concern for bipolar 1 diagnosis.
Yes, without further information or more observations.
Doctor, I then want to ask some questions about your report. I believe it's exhibit, is it 6? Is that still in front of you?
Yes.
Okay. Is that exhibit 6?
Yes, that's the most recent
Okay.
exhibit.
So your report and your opinions that you're testifying to today regarding NGI rely in part based on your observations of Ms. Schabusiness on June 19th, right?
Correct, yes,
And actually, as a result of that interview, based on your observations, you had a concern about her present competency in that moment, didn't you?
yes,
And in fact, your report that you're referencing in Exhibit 6 is sort of a combination NGI report and competency.
yes, that's
And-
what I was asked to do.
And those legally are different concepts, right?
They are,
Competency is sort of in the moment.
yes,
And NGI obviously refers to the date of the offense.
the time of the offense,
Okay, so during your interview with Ms. Schabusiness, you had a concern about her competency.
yes,
Objection,
Yeah.
let's move to strike.
Yet you're using her statements to form your NGI opinion.
her statements, my observations, but not just that 2-hour interview. It was the entire information I had about the case. But yes, you're right. During the interview, it helped me to form my opinions because I submitted a mini report months before that where I couldn't make an opinion because I hadn't been able to interview her. That was, well, both competency and NGI.
Thank you. So then I want to ask about malingering. What does that mean to you?
Malingering is intentional faking of symptoms. Could be about anything, any symptoms, but in the psychiatric profession, malingering is intentional faking of mental health system.
Is that sort of a synonym for feigning or something like that?
Yeah, that's a fancy. Yeah, malingering, feigning. Yeah, faking. I simplify it. Faking.
Sure.
Intentional faking.
And you would agree that's been a concern for evaluators who have met with Ms. Schabusiness.
Yes.
Dr. Seipel had that concern, did he not?
I think he concluded, if my memory's right, I think he concluded that's it. Yes.
I think you're right. Dr. Seipel concluded she was faking, right?
Yeah, I believe so.
And it was a concern raised by Dr. Lucetta, was it not?
Yes, definitely.
And again, she was a
Indeed.
expert retained by the defendant.
Yes,
And that she suggested these potential for feigning should be explored further.
exactly.
And in fact,
Impatient.
And in fact, in your field, there are tools that can be used to help determine if somebody is accurately providing you information, right?
Yes,
One of those is the MMPI.
yes.
And those, have you used those before?
Oh, yeah.
And they're helpful for you to know if a patient is providing you accurate information.
But
I'm sorry.
yes, but you have to take that. It's one part of the clinical evaluation, but you got to evaluate it with other information to decide if it's an accurate test result.
Sure. But you need that information to then know if it's accurate, right?
You need what information?
You need to perform the test.
You don't have to perform. I don't have to perform fancy 500, 300. I don't have to do that. That's not a requirement. Psychiatrists don't do psychological testing. So sometimes I might do it, but I've done many evaluations without that when I have enough other information that you're not required. There's nothing that says you're a psychologist, you got to do MMPI. No, you don't have to do that. But I've done it many times.
And Doctor, I wasn't suggesting that. What I was suggesting is you mentioned that you need to take that test into account and see if it's accurate, essentially, right?
If you've done the test,
Yeah.
sure. Or if somebody else, like in this case, it had been done by all these other people. So I consider that information, and that they found that, yes, she had, the other thing, she had over-presented. We call it the test can detect when you're over-presenting a symptom, like, oh my God, I really got a bad headache, really super, like that, you over-present it. It basically, again, it could be faking, but it's just an exaggeration. That's another term we use.
Sure. So, but in your report, again, Exhibit 6, I think you quote, psychological testing by other evaluators found signs of possible malingering or intentional faking of mental disorder symptoms. Is that a fair summary of what you wrote in your report?
Yes.
All right. And at the end of your report, it says, quote, testing can reveal attempts to fake a mental disorder, end quote. Did I quote that accurately? It's on page 9 of your report, Doctor. Last sentence.
Right. Yes.
And so what attempts did you make to use some of those tests to determine if Ms. Schabusiness was faking?
Yeah, good question. I looked at the other psychologists' test results, plus another evaluator done concerning her baby, Child Protective Services. I think he did testing too. So I look at those results. Yes, they showed exactly what you're saying, but then I take that in the context of the rest of the evaluation and my experience and training.
So, Doctor, you did not conduct any of those tests with Ms. Schabusiness on June 19th.
Yes. Or is that no? Which way do I answer that
Sure.
one? I did not conduct any of those tests, right, on whenever
Even though
The day
those
I-
tests can be helpful to determine if a patient is providing you accurate information.
yes.
And you didn't utilize any of those tests in this case.
No.
Asked and answered objection.
Thank you, Doctor. I have nothing further.
Redirect?
It's going to be a bit, Your Honor. Do you want to take a break or should I ask some questions? Okay. With regards to your report and evaluation of my client, did you get a sense that she was feigning or faking?
At times with me, or not with me during our interview, I didn't think that was, or my interview, I didn't think that was faking at all. No. But with other evaluators, and again, the test results, it's my based on my education, my training in this field, my impression was that if there was I don't think there was intentional faking, period. I think we're dealing with my opinion is we're dealing with a genuine mentally ill person who occasionally is treated, takes medications. I don't think she's intentionally faking symptoms, even in the test results. The test results show that she was exaggerating symptoms of a mental illness. However, Dr. Tracy Lucetta, in her report, I believe it's in her writer report, she points out that the majority of people with those feigning, malingering test results, they're later found out not to have been intentionally faking.
When, in your experience, in your training, do people sometimes who are going through a psychological evaluation or some kind of an assessment tend to overpresent? They want to put themselves in a good light?
Sometimes I've done those tests, yeah, and every forensic evaluation, I assess a person for malingering. Everyone, I do. I don't necessarily give all the tests. Occasionally I do, but we have even other tests for just faking. And I
with-
sometimes use that, but yeah, sometimes people do that for various reasons.
With regards to Dr. Lucetta, you read the whole report, correct?
Yes,
And she had recommended transfer to one of the state psychiatric facilities like Mendota Mental Health or Winnebago, correct?
right, for testing, neuropsychological testing and medications, and yes.
And before you wrote your July 3rd, 2023 report, you did consider all of the information, the interview on June 19th, the interviews in February, is that true?
Yes,
And all the records, correct?
yes,
And you're indicating to the court that you did review some of the video clipped information between Ms. Schabusiness and the detectives?
yes,
So you considered all of that information, correct?
yes,
Your opinions aren't just based off of what happened on June 19th, correct?
no,
And as it relates to the DSM-5 manual, the diagnostic statistical manual that psychologists use, you're familiar with the elements for bipolar 1?
yes,
And did Taylor Schabusiness exhibit some of those elements based on what you saw?
yes. And she confirmed she had had those experiences in the past too.
And oftentimes when psychologists do testing, they would do the MMPI, the Minnesota Multiphasic Personality Inventory, correct?
Yes.
It's a series of questions, correct?
The short version is 300.
And then you gotta answer these questions and then you gather information from that. Fair?
Yeah, it's put into it. Nowadays it's put into a computer and
It's a computer test, right?
well, I don't know. I don't have the computer version. I don't know if it's all, I don't know how that works.
Let me ask you this. With the other test, the other gold standard test for psychologists is the MCMI, correct?
Yeah.
The Milan Clinical Multi-Axial Inventory Test?
Yes,
Is that another written test?
it is.
Was it your understanding that Dr. Matthew Seipel did not use the MMPI or the MCMI?
No, he didn't use them.
Other psychologists had already done that, correct?
You're right.
And you reviewed those reports, correct?
Yeah.
So you went right to it and got materials and analyzed things from a psychological standpoint. correct?
Right. I didn't think there was any utility, any use to giving her the whole test again when she had it, I don't know, 3-4 times.
Wasn't that reason?
I didn't think so. No.
In some of these records from Bellin that she was huffing gas, or excuse me, huffing nail polish in 2013.
Yeah.
Object, it's outside the scope of cross.
It's in the exhibit. It's in Exhibit 8. I can grab the exhibit, Your Honor.
I guess I'll need to see exhibit 8 too. Go ahead.
That's true, right? She was, she admitted to huffing nail polish in 2013.
About then, yes.
Your Honor, could I have exhibits 7, 8, 9, 10? With regards to Bellin Psychiatric Center, her discharge summary It does indicate, Access 1, that she had a mood disorder, correct?
I believe so, yes. Was that from the 2012?
Yes.
Yes.
At least at that time, it did talk about hallucinations, correct?
Yes, and when she came in, they,
Doctor, if you
oh,
just focus
yes.
on his question, he has to reference it, okay?
yes,
It did, okay. And Exhibit 9 here, the Nicolay Psychiatric Center Inpatient Mental Health Unit. The initial evaluation did indicate on the bottom, diagnosis was bipolar disorder, correct?
yes,
And on the Exhibit 10, fair to say that the final summary for Nicolay Psychiatric Center for Taylor Schabusiness, she was admitted 3/22 of 2021, admitted with a diagnosis of bipolar disorder, correct? That was one of them.
yes,
And then she was discharged April 12th of 2021, again with bipolar disorder as one of the discharge diagnoses, correct?
yes,
And then on admission, that her thought content showed that she appeared to be having auditory hallucinations and delusions of persecution, correct?
yes.
And suicidal ideation.
I believe so, yes. Oh, yes.
And is it fair to say that based on what you understood, that Ms. Schabusiness did not take her medications after she was released from Nicolay Psychiatric Center in April of 2021?
Yes, that's my understanding.
And that, at least according to that document, her affect was flat?
Yes.
What does that mean, her affect was flat?
Oh, I'm gonna get a little cough drop here. That means that, I mean, facial expression is just emotionless, flat emotions.
As it relates to these other exhibits, Exhibit 9, she was prescribed Abilify for mood stabilization, is that correct?
Yes, and what was that one from? Is it,
The date of service, it indicates 3/23 of 21,
so that was Nicolay?
yes.
Yeah, she was prescribed, yes. Prescribed, first she was on Abilify, I think when she came in, and then they switched her to the longer acting injected medicine just to make it easier, but then she didn't like it because it hurt. The injection hurt.
And at least at Nicolay, she was brought in on an EM1 petition because she was hearing voices, correct?
Yes,
And she was seeing people who were not there, is that correct?
yes.
Okay, no other questions, thank you.
Mr. Saunders, any further questions?
Just very briefly, the question about having a flat affect, about the reported hallucinations, about being brought in on a Chapter 51, that was upon admission into Nicolay, right?
Yes,
When she was testing positive for methamphetamine and other substances.
right, substance use.
Thank you, doctor.
Anything on those topics?
No, Your Honor, thank you.
Thank you, Dr. Yurkus.
I think I did forget to move 7, 8, 9, and 10.
Any objection to 7, 8, 9, and 10?
No objection.
Those will be received.
Thank you.
Your Honor, can I just make sure? A lot of things are going on in my head. Were all my exhibits offered and accepted?
Yes.
Okay. Exhibit 5, if it's not, I'll offer it.
Any objection to 5?
Thank you, Judge.
Ladies and gentlemen, we're going to take our lunch break now. It is 5 after 12. I'm going to ask that you be back in the jury room no later than 1:15. I'd like to get underway right at that time. All rise.
I'm going to talk to my client, Your Honor, about whether I'm going to have her testify, but other than that, no.
Sure.
I may not have her testify. I have to talk to her.
Yeah, and I appreciate that, and that's something I wanted to cover because in my research, they tell judges that we don't necessarily have to make inquiry of a defendant at this phase, but it's best practice to do so, and far be it for me to try to avoid best practice. So I think I would undertake that qualification or that the colloquy with your client when we return and when you advise me whether you have other witnesses. If you're indicating after lunch that she would be your only witness and you don't intend to call her, then I'd have that colloquy before we bring the jury back in,
Okay, Your Honor.
just so everybody knows that.
Thank you.
Then the other thing I want the parties to take a look at, I'm going to provide you after the lunch break, is the jury instructions, and I want you to give some thought to how you want that laid out. My suggestion is that, and I'm open-minded on this, so I just want you to think about it, and you can certainly push back a little bit if you want. That I would give the at the conclusion of evidence, I would give the instruction 160 regarding closings. Then I would have you close. Then I would give a modified version of 100. That's the preliminary instruction indicating to the jurors that I'll instruct them upon the principles of the law, that they shouldn't use any impression that they may have of my thoughts in any way, and that they're to follow the instructions that I give them. So I propose to give a modified 100. I'll modify it over the lunch hour, give it to you. You can take a look at it, and your response might be, I don't want you to give that at all, or I want you to modify it differently, but that I would give 100. I might give 315, Mr. Freilich. That is the instruction that if your client chooses not to testify, I could certainly give that instruction again. Although this is a civil matter and I'm not sure that it's really necessary, but that is a possibility. Then I would give 640, which is mental disease or defect expert opinion testimony, and 605, which is the instruction, the base instruction on this proceeding. And then the jury would go into deliberations. That's what I would propose. I'll give you my draft of those instructions after lunch. You can think about it and we can have further conversation then. Anything else before we break, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor. Thank you.
Okay, then I'd ask you to be back in about an hour. That'll be 1:05. The jury will be back at 1:15. We can take up anything then. All right, we're in recess.
Thank you.
Council, Dr. Lynn is asking whether or not she's Be seated. Okay, we're back on the record. I'm going to turn to you, Mr. Freilich. First of all, other than potentially your clients, do you have any other witnesses?
I do not, Your Honor.
Okay, and then have you had an opportunity to speak with your client about her testimony at this phase of the trial?
Yes, Your Honor, I spent extra time with my client, Ms. Schabusiness. We talked about her right to testify at phase 2 of this proceeding, the NGI phase of the proceeding. She understands what that means. She understands that she could take the witness stand and answer questions and testify about various topics. I've also explained to her that she has a right not to testify, that she doesn't have to get up on the witness stand, that she can stay at counsel table and remain silent. That's her right. That's her choice. I gave her time to think about it, to reflect on it. She had questions. I answered those questions. We had a good dialogue and conversation on this particular topic. She's advised me that she wishes to waive her right to testify. She's not going to take the witness stand.
Mr. Business, your attorney tells me that you choose not to testify at this phase. Is that correct?
That is correct.
Okay. You understand that you have a right to testify, and you also have a right not to testify. And if you don't testify, your choosing not to testify can't be used against you. Do you understand that?
Yes, I do.
Okay. You understand those rights belong not to Mr. Freilich. They don't belong to me. They don't belong to the state. Those rights are yours and yours alone. Do you understand that?
I do.
Do you feel you need any more time to talk to Mr. Freilich about this decision?
No, I don't.
And it's your decision not to testify here today. Is that correct?
Correct.
Okay. Any further inquiry the state would like me to make regarding that?
No, thank you.
Mr. Freilich, any further inquiry you'd like me to make regarding that issue?
Only if the court would inquire as to whether she felt any pressure or coercion in order to make this decision.
Mr. Business, do you feel you've had any pressure by anybody or coercion to make this choice?
No.
Okay.
Thank you, Judge.
I'm satisfied that Ms. Business understands her. She's had a full opportunity to speak with her attorney about it. And she's made a choice here today, freely and voluntarily, not to testify at this phase of the trial. And I'm going to accept that, and we are going to move forward. So I think how the matter would unfold then is when the jury comes back in, I'll ask Mr. Freilich if he has any further witnesses to call. Based upon what I've heard, the answer will be no, the defense rests, and then we would move to the state. And as I'm presuming the state is ready to call its first witness.
Yeah.
Okay. And then I did want to place on the record, because I was advised that when we excused Dr. Layton, we weren't on the record, but there was no objection to Dr. Layton. It's too late now. Both parties indicated there was no objection to her being excused, and that's what I did. Is that correct, Mr. Freilich?
That's accurate.
And Saunders? Yes. Okay, and I just want to confirm, we don't need to go over these now. The jury has already been waiting a little longer than I told them they'd have to. But I did place on the on council table copies of proposed jury instructions, and then also just recently copies of what comes in the form of jury instruction 605B, but it's not a jury instruction, it's a proposed verdict form. Did both parties get a copy of those, Mr. Freilich
Yes.
and Mr. Saunders?
Yes.
Okay, we can discuss those at the conclusion of evidence, but at this time then, I'm going to bring the jury in. All rise to the jury. Okay, be seated. All right, We are back on the record this afternoon. The case is still with the defense. Mr. Freilich, do you have any other witnesses to call?
Your Honor, the defense rests at this time, no other witnesses.
All right, then the matter turns to the state. I don't know, Mr. Lizay or Mr. Saunders, who's going to be questioning the first witness. So Mr. Lizay, your first witness?
Your Honor, the state calls Dr. Matthew Seipel.
Okay. Dr. Seipel, if you want to step forward here and
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God?
I do.
Please have a seat and state your name for the record.
Matthew Seipel. My last name is spelled Seipel.
okay, then the witness is yours, Mr. Lizay.
Good afternoon, Dr. Seipel.
Good afternoon.
How are you currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated and the Wisconsin Forensic Unit, where I perform forensic mental health assessments on a full-time basis.
How long have you been with the Wisconsin Forensic Unit?
I began with the Behavioral Consultants and the Forensic Unit in September of 2020 as a postdoctoral forensic psychology fellow, and I've continued with those organizations since February 2022 when I obtained psychology licensure in the state of Wisconsin.
And you indicated that your full-time duties is to perform forensic evaluations. Is that right?
Yes.
What types of evaluations do you typically perform?
I complete competency to proceed examinations, mental responsibility or NGI evaluations, evaluations of people who are petitioning for conditional release from the state mental health institutes, as well as legal guardianship, and several types of juvenile evaluations.
You indicated that is your full-time employment. Do you know about how many of each of those evaluations you might perform in a calendar year?
And so I would say in total, I've completed over the past 3 years, roughly 1,000 across those types of evaluations. So in a calendar year, it would break down to typically at least 300 evaluations. About 3/4 of those would be competency evaluations. And then roughly, I would say another 10 to 20% would be NGI evaluations.
You indicated that you are a licensed psychologist in the state of Wisconsin.
Yes.
What does that process entail?
And so to become a licensed psychologist, one needs to complete a doctorate in psychology from an institution that is either accredited by the American Psychological Association or determined to meet equivalency of those accreditation standards. And then at the time that I obtained licensure, 1 year of full-time postdoctoral supervised practice was required. I believe that standard has changed, but that was the standard for licensure at the time that I gained my license.
And you indicated that you must have that doctoral degree. Where did you obtain that degree?
I was from Iowa State University.
And do you have, can you just go through briefly your education prior to that degree?
I completed a bachelor's degree in psychology from Cardinal Stritch University, as well as a Master of Science in Clinical Mental Health Counseling from Marquette University before completing my doctorate at Iowa State.
And doctor, through your professional work at the Wisconsin Forensic Unit, did you have an opportunity to work on the present case, state of Wisconsin versus Taylor Schabusiness?
Yes, I did.
How did you become involved in that case?
And so I was requested to complete 2 court-ordered competency evaluations in this matter.
When you say court ordered, does that mean that the court is the party that retained you rather than either the state or the defense?
Correct.
And when was that first evaluation? When was the first report filed?
That was in November of 2022.
And when was the second report filed?
That was earlier this month in July of 2023.
Can you, you mentioned that you were retained by the court to do a competency evaluation, and earlier you also mentioned that you do NGI evaluations. Can you explain for the jury the difference between those two types of evaluations?
Yeah, so those are 2 entirely different types of evaluations that are guided by 2 different state statutes. And so competency pertains to a defendant's current mental status. It is independent of the mental state at the time of the alleged offenses, and it pertains to whether or not the defendant presently has substantial mental capacity to understand the pending proceedings or to meaningfully assist in their defense. Whereas the state statute for NGI dictates it is about the defendant's mental state at the time of the alleged offenses, and specifically, was there a qualifying mental disease or defect that contributed to a substantial lack of capacity to appreciate wrongfulness of conduct or to conform conduct to the standards of the law?
And you indicate that you have substantial present experience in both of those types of evaluations. Is that correct?
Yes.
Now, they are different evaluations with different standards. However, are the materials used to evaluate those often similar?
I would say that collateral records are critical in both evaluations, although in competency, those records would focus most heavily on the present time and present functioning, whereas for NGI, it would be focused upon functioning at the time of the alleged offenses.
And can you talk about the records that you reviewed regarding Ms. Schabusiness for each of the two competency evaluations that you performed?
Yes, and so I reviewed the criminal complaint for the underlying matter. I reviewed all previous psychological evaluations that were completed in reference to this case, including competency and NGI reports from multiple examiners. At both times, I reviewed her contemporary treatment records from the Brown County Jail. And during the most recent evaluation, I also had the opportunity to review a discharge summary from a treatment episode at the Nicolay Psychiatric Center in 2021.
Did you, subsequent to the evaluation, were you also provided with copies of materials from an inpatient stay at Balance Psychiatric or two different inpatient stays at Balance Psychiatric?
Yes, after submitting my most recent report, defense counsel provided me discharge summaries pertaining to those two episodes of inpatient care.
And were all of those records taken into consideration when you either rendered your opinion or provided testimony at competency hearings in this case?
I would say that all of the sources that I mentioned initially were considered in reaching my opinion in my report. And then those Bellin records I did consider in preparing for testimony, but they did not alter any of the opinions offered in my report.
And in addition to reviewing collateral records, did you conduct personal interviews with Ms. Schabusiness?
Yes, I did.
And what were the dates of those interviews?
And so the most recent interview, I'm just referencing my report here, was on July 12th of 2023. And for the initial interview, I would reference to refresh my memory, that report from November of 2022, the date of the interview was November 17th, 2022.
And were both of those in-person interviews?
Yes.
And can you estimate approximately how long you met with Ms. Schabusiness in those interviews?
On both occasions, it was roughly 90 minutes, perhaps give or take a few minutes.
Doctor, when you were reviewing the records and ultimately when you had to come to an opinion in this case, had you encountered prior diagnoses that had been assigned to Ms. Schabusiness at various points in time?
Yes.
Were you aware that at some point in time she had received a bipolar diagnosis?
Yes.
And do you recall where that came from?
That was during her inpatient treatment at the Nicolay Psychiatric Center in 2021.
And Doctor, what did you note with respect to that particular diagnosis? Were there any concerns when you saw that?
Yes, a concern I had with that diagnosis is that for one to be diagnosed with bipolar disorder, it's specifically within the diagnostic criteria for that condition that the symptoms cannot occur exclusively in the course of substance intoxication. And I noted that there's multiple collateral sources suggesting that she was abusing methamphetamine very extensively leading up to that treatment episode. So I was unable to really see how the treatment providers could have parsed out to what extent any psychiatric instability derived from the methamphetamine use versus an actual underlying mental illness.
And did you have an opportunity to review the discharge summary from Nicolay Psychiatric?
Yes.
And in that discharge summary, is there a discussion of how she presented upon arrival compared to how she presented upon her release 21 days later?
Yes, it was noted that there was a remarkable difference and that psychotic symptoms were evident upon admission, including hallucinations and very disorganized behavior, although those symptoms were determined to be largely resolved by the end of that treatment episode.
Does that suggest anything to you with respect to the substance abuse that was indicated at the outset?
And so it's, again, difficult to disentangle to what extent that improved mental status resulted from any medication she received in the facility versus her mere forced abstinence from intoxicants.
Based on your professional education and experience of the types of symptoms that were noted upon arrival at Nicolay Psychiatric, can those symptoms also be associated with the methamphetamine use solely?
Yes.
So it's possible for someone to manifest those symptoms solely based on meth use without having any underlying mental health illness.
Objection
Yes.
calls for speculation.
Overruled.
Yes.
You indicated that you had the opportunity to review reports from other evaluators who met with Ms. Schabusiness and provided opinions in this case. Is that correct?
Yes.
Did you note whether or not any of the other evaluators shared similar concerns about the bipolar diagnosis assigned to her by Nicolay Psychiatric?
Yes, I noted that in Dr. Engen's mental responsibility evaluation, she took most specific and direct issue with the basis for that diagnosis. And she ultimately, in her report, offered that she did not see sufficient support to assign a diagnosis of bipolar disorder. I also noted that, for example, in Dr. Lucetta's competency report, while she did not necessarily completely rule out bipolar disorder, she also noted again that the substance abuse was a significant factor leading up to that diagnosis, and she merely essentially sought to rule out that diagnosis but did not assign it.
So I want to just sort of speak generally about bipolar. Can you describe for the jury what bipolar is and what is required to diagnose such a disorder?
Yes, and so there are two different types of bipolar disorder. There's bipolar 1 disorder, which is a more severe condition, and that is the diagnosis that has appeared in some of the records in this case. Bipolar 1 disorder is characterized predominantly by manic episodes, which are periods of it lasting at least a where where more often than not the individual has a significantly elevated mood. They may behave impulsively, erratically, have a decreased need for sleep. And in some instances with bipolar 1, that is alternated by depressive episodes, which typically last at least 2 weeks and are largely the opposite of mania. That means there's a persistently low mood, low energy, feelings of worthlessness, guilt, or hopelessness, things of that like. Whereas bipolar 2 disorder has hypomanic episodes, which are not as prolonged or severe as a manic episode. And by diagnostic criteria, someone must also experience depression in order to qualify for bipolar 2 disorder.
So is it fair to say that to diagnose someone with bipolar 1, we would have that expectation of seeing those prolonged manic episodes, at least one instance of a prolonged manic episode?
Yes, and it would need to occur outside voluntary substance intoxication.
Is it possible for a person who has been diagnosed with a bipolar disorder, is that the type of condition that could occasionally wax and wane over the course of someone's lifetime?
To the extent that someone does indeed meet diagnostic criteria for bipolar disorder, yes, there certainly can be a waxing or waning or a cyclical pattern of symptoms.
I also want to harken back to the fact that you have done NGI evaluations. Is that correct?
Yes.
And is bipolar a condition that can sometimes contribute to an opinion that someone does meet NGI criteria?
Yes, it certainly can.
And under what circumstances might you expect to see that?
Yes, and so in order to reach an opinion of supporting an NGI plea in the context of bipolar disorder 1, there would need to be a firmly established diagnosis of bipolar disorder, again, in the absence of substance intoxication. And there would need to be a very direct linkage between the symptoms of that mental illness at the time of the alleged offenses and the substantial lack of capacity to either appreciate wrongfulness or to conform conduct to the requirements of the law. It's not enough for the defendant to simply be symptomatic, but that linkage needs to be established with the lack of capacity.
When you talk about establishing that linkage between the crimes alleged and the mental illness that's been assigned to an individual, what sorts of facts or circumstances do you consider when you do NGI evaluations?
And so there would need to be converging data sources indicating that indeed the defendant was symptomatic of that legitimate mental illness at the time. And there would need to be, conceptually, it would need to make sense for the alleged misconduct. There would need to be some sort of reason that mania, for instance, would have caused that behavior. There would need to be evidence to suggest that the person was fundamentally unable to control their behavior. And so again, that would typically comprise a pattern that extends beyond that one momentary act, but it would need to be a broader pattern encompassing that time frame.
So if you were evaluating whether someone's bipolar disorder might be causal of the criminal offenses, would it be significant to you to evaluate the defendant's symptoms or how someone presents immediately before and immediately after the alleged offenses?
Yes, those would be critical time frames in which to gather as much data as possible.
Is that because one would expect that someone with bipolar wouldn't manifest those symptoms solely for a short period of time, but typically over a much longer period?
Yes, that is
Objection
correct.
calls for speculation.
I think it calls for his professional opinion.
Overruled.
Yes, it would be expected to see, again, a symptom duration longer than just the mere moments of committing a criminal offense.
Doctor, I want to quickly return back to some of the other records that had been mentioned. You indicated that you did have an opportunity to review the medical records from Bellin Health from two different stays that Ms. Schabusiness had, one in 2012 and one in 2014.
Yes.
And I'll first call your attention to the 2012 records. If you recall those, do you remember if Ms. Schabusiness was assigned a diagnosis by the treatment providers at Bellin Health at the outset of her stay in 2012?
She was assigned a diagnosis of mood disorder not otherwise specified.
So she was not assigned a bipolar diagnosis at that time. Is that correct?
Correct.
And then in 2014, did she likewise have some sort of diagnosis following her 3-day stay in Bellin?
She was again assigned a diagnosis of mood disorder not otherwise specified, and they did add, which is not diagnosed per se, but they noted alongside the diagnosis a history of psychosis. But in looking closer at the records, that history of psychosis derived squarely from an adverse medication reaction, which prompted the initial inpatient stay. So she was prescribed sertraline, and then only after that did she begin to have psychotic symptoms, and those symptoms resolved as soon as that medication was discontinued.
Again, she was not assigned a bipolar diagnosis in 2014.
Correct.
Dr. Seipel, you indicated that you did have an opportunity to review Dr. Litton's report from July 3rd of 2023.
Yes, I did.
Again, what type of report from a forensic standpoint was Dr. Litton's report?
It appeared to be a combined competency and NGI report.
In your experience and training, is it best practice for someone to engage in a combined report of both competency and NGI?
Typically, a separate report would be submitted to address each issue independently.
What are some of the reasons why you might not combine those two reports?
For one, there can be information introduced in the issue of criminal responsibility that might be inappropriate to be contained within a competency report. A competency report is not supposed to contain incriminating information with regard to the alleged offenses. But also, from a psychological standpoint, it makes it difficult to parse out which data and which arguments are directed at each respective issue if they're addressed along with each in the same report.
Is it particularly concerning if you come to a conclusion that a person is not presently competent, that you would also rely on that information to form an NGI opinion?
I would say that it's not inappropriate if that's a data point that is considered, but that there should not be a strong linkage in that reasoning, as again, it's two different legal issues pertaining to two different time points.
Doctor, when you looked at that report as it relates to NGI and Dr. Litton's report, I'm just going to ask you generally, did you have any concerns with the methodology that was shown in that particular report?
I found that it seemed appropriate data sources were consulted, at least that's what the methods section suggested in that report, although there was essentially no discussion or review of the discovery materials that were reviewed, and really no account from a defendant's perspective of the alleged misconduct, which are very critical pieces of information that would always be included in an NGI report.
So those pieces of information that you just discussed, like the account of the offense and the specific discovery materials outlining the offense, why is it important to include that type of information in the report?
Because again, the statute for NGI pertains squarely to the moments of the alleged offense, and that is the data that most directly captures those moments. And so it becomes somewhat of a black box issue if those moments are not discussed in the report and inferences instead are appearing to be made based upon presentation at other time points. That's not sound professional reasoning with regard to the issue of NGI.
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Schabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Were you able to determine whether or not Dr. Litton actually assigned a diagnosis herself?
It seemed implicit in the report that she concurred with the bipolar diagnosis, although it was not explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that typical in your experience to not assign a diagnosis during such an evaluation?
In an NGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here.
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
And Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Yes, the greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Schabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Litton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Schabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
Yes, I did.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Litton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed. And jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I would object only because that calls for hearsay. I apologize, but
I forgot where you were in your answer, but if you're
another question.
sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report as part of a competency instrument that she administered to the defendant. Embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known. And the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent, even for a patient with legitimate schizophrenia.
And did you note whether or not Dr. Lighton performed any such psychological testing to determine the validity of the symptoms that she was observing from Ms. Schabusiness?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes, in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. Schabusiness when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicative competency.
Can you explain that maybe just in a little more layman's details?
Yes, and so to the extent that the defendant would have presented similarly as she did with Dr. Lighton, for instance, presenting herself as very distracted by hallucinations, unable to supply linear or coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point, that the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
Now, Doctor, you also had an opportunity to review the report of Dr. Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to the issue of NGI.
Now, some of the shortfalls of Dr. Lighton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Lighton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that again would have been in that time period leading up to this offense. And she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. Schabusiness's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant. And then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related to general diagnoses of a mental health condition, but can you talk briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. So to the extent that an examiner cannot rule out the sequelae of that voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Cross-examination, Mr. Freilich?
Thank you, Your Honor. Dr. Seipel, good afternoon.
Good afternoon.
You prepared two reports concerning Taylor Schabusiness, correct?
Yes.
One in November of 2022 and then one in July of 2023, correct?
Yes.
And You received police reports, correct?
I did not review the police reports.
Did you review the criminal complaint?
Yes,
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the two gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Yet you criticize Dr. Lighton for not doing it, correct?
Yes,
Now, you've been a licensed psychologist since February of 2022, correct?
yes,
That's when you obtained your license to practice and do evaluations and reports and all of that, correct?
my license enabled me to practice independently, although I performed all of these evaluations under supervision from September 2020 up until that time.
In September of 2020, that's when you were a fellow.
That's when I began my postdoctoral fellowship in forensic psychology.
When you've had a chance to review Dr. Lighton's curriculum vitae, correct?
Yes,
You've had a chance to review her evaluation from July 3rd of 2023, correct?
yes,
As far as experience level, she has more experience than you. Is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
And with regards to Dr. Christina Engine, she works in the Wisconsin Forensic Unit as well.
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the two of you are aligned as far as opinions in this particular case. Is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the ultimate recommendation is the same, correct?
I guess I'm not sure what you're asking, sir.
That you and her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County jail records, correct?
Yes,
You reviewed Bellin Health records that I sent, correct?
yes,
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
yes,
You reviewed a lot of mental health records, correct?
yes.
Fair to say that Taylor Denise Schabusiness does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill, at least in 2021. Is that fair?
According to that court order, it would suggest that, yes.
And then she was on a medication order in order to take psychotropic medications for that same period of time, correct?
Yes, it is my understanding she was court ordered to medication compliance.
A lot of different doctors evaluated and took a look at Ms. Schabusiness, correct?
With respect to the pendency of this case or more generally?
Just with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins, yes.
Yes,
Dr. Tracy Lucetta,
yes,
Dr. Diane Lighton,
yes,
yourself,
yes,
Dr. Christina Engine.
yes.
With regards to Ms. Schabusiness's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristata?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristata, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood stabilizing properties as well.
And fair to say that through Brown County, through Nicolay, that Ms. Schabusiness was given a diagnosis of bipolar disorder.
Yes,
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged.
Yes,
She was discharged, after she had her baby.
what was the question, sir?
Do you know? I'm sorry. Do you know if she was discharged after she had her baby?
I do not believe she gave birth during the course of that hospitalization.
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Schabusiness suffering from paranoia?
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center where I saw the hallucinations mentioned.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay when she had heavily been abusing methamphetamine recently.
You've been a doctor for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many, many different kinds.
With all different sorts of problems, correct?
Yes,
And you've dealt with people who have had drug addictions and things of that sort, correct?
yes,
You've gone to seminars with regards to how substances can affect the brain, correct?
yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
And would it be fair to say that substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
What causes memory impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly, if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
Yes, it is.
Can that get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
And can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
People are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. Schabusiness had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have occasion to, when you met with her, to observe that she had a tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engine or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. Schabusiness identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her in November of 2022 or July of this year?
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
In some of the records, did you note that it indicated her affect was flat when approached?
Yes, there were some indications of a relatively flat or diminished expression in her emotional presentation, yes.
What does that stem from? Do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
Also in these progress notes, did you indicate, or did you review, excuse me, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that in the Nicolay notes as well, yes.
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time, yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms mentioned in the records as well.
Did you, at least in some of the, either the jail records or the Brown County records from Nicolay, that she talked about wanting to die and go to heaven to see her mom?
Yes, I do recall seeing such comments made.
And in reviewing these records, because there were a lot of them, did she indicate, at least in the records when she was at Brown County at Nicolay, that she was hearing voices that would get heavier at night?
I do believe, yes, there was a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night, they'd be more pronounced at night than the daytime?
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
And it's true, right, that there were discussions about her getting this Aristata injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Ms. Schabusiness would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review and you have a good memory, but it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent treatment records.
And Ms. Schabusiness was given, apparently at Nicolay, from what you reviewed in these notes, what are her coping skills and what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
With regards to Dr. Lighton, she says that she believes that my client, Ms. Schabusiness, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Schabusiness's ability to know right from wrong at the time of the.
Worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed opinion compared to Dr. Lighton, correct?
Again, I did not opine on the NGI issue.
Thank you. Nothing further.
Be direct.
Just briefly, I think you were asked a great deal again about the the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. And do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. Schabusiness have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged misconduct,
Correct.
I would say that from what I saw, Dr. Lighton was the only one that, and again, it wasn't really directly discussed, though at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022. Is that correct?
I did not see any indication of her being actively involved in psychiatric treatment, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether or not an NGI offense or an NGI defense is appropriate for Ms. Schabusiness in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, you are. Thank
Okay,
you, Dr.
Thank you,
Seig.
Doctor. You can step down. State's next witness.
State calls Christina Engine.
Doctor, if you just step forward here, and then before you have a seat, if you could turn and face her and raise your right hand, she'll place you under oath.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God. Yes. Please have a seat and state your name for the record.
Christina Engen, CHRISTINAENGEN.
Mr. Saunders, the witness is yours.
All right, Doctor, how are you employed?
As a psychologist with behavioral consultants,
And how long have you been employed with behavioral consultants?
12 years.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
And I guess what do you do as a psychologist with behavioral consultants?
I conduct almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is forensic evaluations? What does that mean?
The court principals will approach a psychologist with a psycholegal question. So a psychological question that applies to the legal situation. And our job is to help answer that and to provide information to the trier of fact, the judge or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess, what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal responsibility.
And you have performed those evaluations in the past?
Yes.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right. Mark exhibit 12. Do you recognize that?
Yes.
And what is that?
It is my curriculum vitae.
And does that appear to be up to date?
Yes,
All right. That's a document that you prepared.
it is.
I'd move 12.
Any objection? No objection. 12 will be received.
Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology. Applicants can specialize in several different areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
With the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. What are some of those?
I've provided guest lectures for Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Corrections psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor Schabusiness?
Yes.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
And is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Doctor, I'm showing you Exhibit 13. Do you recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
And does that contain your, I guess, factual findings and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
Any objection?
Subject to cross, Your Honor, no objection.
13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Yes, the evaluation consists of a clinical interview, so a meeting with Ms. Schabusiness. I also conducted a full discovery review, so review of all of the police reports, videos, documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
So I want to first start with the clinical interview that you mentioned conducting. What date was the date that you met with Ms. Schabusiness?
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
And October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes,
And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Schabusiness from February 23rd of 2022?
Yes,
Was that a rather lengthy interview?
it was.
Did you review the entirety of it?
To the best of my recollection, I believe that I reviewed the vast majority of it. If I would say the majority of it.
Were there a lot of dead parts in the middle of it?
There were, but I thought it was important to review that video footage to listen for comments that Ms. Schabusiness would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case.
Yes,
The medical records that you reviewed, you mentioned there were prior competency evaluations, but also Brown County Health Services records. Is that right?
correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right. And when was that?
That spanned March of 2021 to April 2021.
And you then indicated you also conducted a, I guess, personality test, or what was the fourth collateral source you reviewed?
I can administered an objective personality test. It's called the Minnesota Multiphasic Personality Inventory, third edition. The acronym is MMPI-3.
So I want to then go through your report, if that's okay, Doctor. Beginning on page 2. So one of the things you start with is called relevant history. Do you see that section of the report?
Yes.
And I guess why is it important to review the history as part of your NGI evaluation?
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Schabusiness's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue. So can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Schabusiness's mental health history as well,
Yes.
as we talked about. As well, did you review her during the course of your clinical interview with Ms. Schabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting as you do the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
As part of the clinical interview with Ms. Schabusiness, do you get a narrative from her about the alleged offense?
To the extent that I was able, I did. Ms. Schabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she did not. She reported she did not regain memory until after her arrest.
With respect to Ms. Schabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety. And I understand that she struggled during this time period, was feeling what sounded like to me some alienation in the workplace. Not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those, you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those are all kind of leading up to the date of the offense.
Correct.
With respect to February 21st, 2022 specifically, did she have a narrative about sort of the timeline of events leading up to the offense?
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she was staying in. I believe they were smoking marijuana. She expressed an interest in finding methamphetamine, and so she said that she went on a, quote, meth hunt, end quote.
Did she indicate whether she had ingested methamphetamine leading up to the homicide?
Yes, she told me that she took 52 hits of methamphetamine.
Did she also refer to that amount as, quote, a lot?
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes.
And then you indicated around the time of the alleged offense, she reported having no memory of that time.
Correct.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement.
Yes.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the October interview.
You also indicated during the interview with Ms. Schabusiness, you performed some psychological testing. Is that right?
Yes.
What testing did you administer?
It was the MMPI-3.
What is the MMPI-3?
It's a very well-established psychological instrument dating back to the 1940s, very well researched and respected. So this test can provide indication of different types of psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
So the validity indices, I think I said that right, that you mentioned, I guess, what does that mean?
What that means is that built into the test are several items that, when they're all combined at the end, they'll indicate if a person is answering questions in a forthright manner, if they're minimizing their symptoms, or potentially if they're exaggerating their symptoms.
So is this test like a true false questions, or how does this test administered?
Correct. It's a true false instrument.
And I guess what were some of your findings with respect to Ms. Schabusiness's performance on the MMPI test?
Well, first, let me be clear that the test does not say anything about Ms. Schabusiness's functioning. In February of 2022, it only provides information about her functioning at the time of the test. So what was relevant from that was that there was indication of symptom exaggeration. She responded to items, she endorsed a number of symptoms that genuine individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. And there's a good point. So this testing is sort of in the moment as you're meeting with Ms. Schabusiness, is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Ms. Schabusiness's self-report could not be taken at face value.
And I think you state that anything that's not objectively observed should be closely scrutinized. Is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
And one of the phrases you used was endorsed symptoms. What does that mean?
For example, I'm just making this test example up, but I feel depressed. A true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Ms. Schabusiness, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Ms. Schabusiness was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
And in your report, you outlined, I guess, 3 mental health conditions. Is that right?
Correct.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Schabusiness's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Schabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this indicated to me the presence of psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So mental health conditions, in your opinion, are different from mental diseases or defect.
Correct.
And the three diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding, based on the case law, that the defendant would be subsequently responsible for all alterations of thinking, judgment, behavior related to that intoxication.
I guess, were you aware of any information in the materials you reviewed that Ms. Schabusiness's methamphetamine use was anything but voluntary?
No.
And that obviously she reported a history of using methamphetamine to you.
Yes.
So I guess, were you of the opinion that she was not naive to its effect?
Correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess, in your experience and in your education training, are you aware of some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
Excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms. So misperceptions of reality, and paranoia.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes.
And did you consider, I guess, the applicability or the appropriateness of a bipolar 1 disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar 1 disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar or indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar 1 disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And are you aware of any of those symptoms absent in the context of methamphetamine use?
I am not aware of a time ever that Ms. Schabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar 1 diagnosis was applied to Ms. Schabusiness in April of 2021.
Yes.
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
Yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Schabusiness.
Objection leading.
Just clarifying the testimony. I'm just clarifying the testimony. Your Honor.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Schabusiness with?
Yes, also offered at Nicolay or Nicolette, I'm not sure the pronunciation. There was a diagnosis of, I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe that, I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Okay. Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
Okay, and what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect, that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found in my report, I outlined various different factors, but focusing on the two issues, ability to conform behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement expressing apologies to the victim's sister, indication that she was trying to conceal the body was dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find the self-reported amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was not, that she was reporting non-credible memory impairment.
Do you have just a few more questions, Doctor? Your report was done in November of 2022, is that right?
Yes,
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
yes.
And who authored those reports?
Diane Litton?
Okay. And in your review of Dr. Litton's report, did any of her findings or conclusions alter your opinion from November of 2022?
No,
I guess the same opinions you're testifying here to today?
it did not alter my opinion.
And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination, Mr. Freilich.
Would we be able to take a break right now or not?
Okay, ladies and gentlemen, we'll take a 10-minute break and we'll resume. All rise for the jury. And Doctor, you can step down. All right. We'll be in recess then for 10 minutes. I'd like the attorneys to return. Obviously, 10 minutes is a little bit before 3. I'd like you here a little bit before 3 so I can speak to you a little bit about these instructions, okay? So recess.
requested.
Okay, be seated. Okay, before we bring the jury out, just briefly, I've had distributed to you a set of instructions and a proposed instructions and a proposed set of outline as to how they should be given. There's certainly other instructions that could be given, that were given to the jury the first time regarding objections of counsel, improper questions, things of that nature. Although they've gotten all those instructions already, I'm not sure the need to do that. But I'm going to start with the state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out, alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we could do the closings. When I look at 605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? But then in question 2, it says, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect. Because it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is, you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions, and I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page of 605B, the comment about the possibility of using the phrasing mental disease and defect, and then it cited the case. I don't think that's appropriate to use and in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one, but it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to and. Nonetheless, I wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to as a result of the mental disease or mental defect. Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an or, Mr. Freilich, versus an and?
I've always thought that it was an or, Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as or. You're not asking for anything else. You don't have any objection to or, do you, Mr. Saunders?
No.
Okay, very good. I'll add that one word in, and then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay, then anything else before the jury comes in, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. So the jury. Doctor, if you want to step forward. Okay, be seated. All right. Then we're back on the record, and we're up for cross-examination. Mr. Freilich, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much. Dr. Engine, good afternoon.
Hello.
So you work for behavioral consultants, is that correct?
Yes.
That's in Milwaukee.
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
And with regards to this case, you did not do a competency evaluation. You did an NGI evaluation.
Correct.
You met with Taylor Schabusiness, correct?
Yes,
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail on October 12th and October 21st of 2022?
Yes.
Have you met with her since?
No.
So it's been, is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first time that you tried to see her, there was some sort of a security issue going on and you were not allowed to see her, is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years. Is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
So I provided, an example that I made up, but there's various statements, and the respondent is asked to respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
How long does it take to get through the test?
In the case of Ms. Schabusiness, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
Sometimes longer if you have difficulty reading.
Could be,
So that was done. You reviewed some police reports in this case,
yes,
a criminal complaint and some video footage. Is that fair?
yes,
Photographs.
yes.
How did you get that information?
It was provided as part of the entire file that's started coming along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
And then looked up some information on DCAP, the Circuit Court Access Program,
Yes,
basically a search on the internet of her background,
correct.
specifically her prior record.
Yes,
And then you looked at some Brown County Human Services records.
yes,
Would that be the Nicolay Psychiatric Center records?
yes,
So you looked at those.
yes.
Then you looked at some jail records.
I did not, I requested the jail record, but they had not been received.
And was there a request to see some Purveya health records?
Yes,
Did you get to see those?
no,
Did you review any Bellin health records?
no,
Was it your understanding that Taylor Schabusiness had had some treatment stays at Bellin Health in the past?
yes, I understand that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment,
So you were missing the Bellin records and the Purveya records, correct?
correct.
Now, you got some relevant history, some background information about my client, correct?
Yes,
You found out that she was born in Chicago, correct?
yes,
She was raised in Lindenhurst, Illinois. Is that fair?
yes,
And then she moved to Green Bay in 2009 at maybe age 11.
yes,
And that same year, her mother passed away.
yes.
Was it your understanding that her mother died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes,
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
yes,
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson, Mississippi,
yes,
then came back to Green Bay.
yes,
That's kind of the progression. Is that fair?
correct.
You found out that she was also married in February of 2020.
Yes,
And when you were involved, had she given birth to her child?
yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Yes,
In Texas.
yes,
Did you garner information that she was in an abusive marriage with her husband?
what I gathered was that she was married. There was discord within the marital relationship, which led Ms. Schabusiness to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the
did you-
nature of the relationship.
Did you get any information that her husband was hitting her in the head?
Objection
No.
asked and answered. She doesn't know.
No, that's a different question.
Go ahead. Overruled.
No,
Okay. So you got some background regarding her life, correct?
yes,
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
And was it such that she had some issues with school, suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
The information that you have as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, doctor, upgraded your report by looking at additional records, Bellin Health and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain. And I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Your colleague in the field is Dr. Matthew Seipel, correct?
Yes,
And did you confer with him with regards to, your opinions, your assessment, your evaluation?
no.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
That is something that could have been done, correct?
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the issue.
Does it surprise you that, as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
You don't share information then, correct?
Only upon request, if it's appropriate, if it would be appropriate and permissible and specifically requested, but we don't, as a general practice, pass records between doctors.
If you had received these records, you could have done a supplemental report. Is that fair?
If it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
Now, as it relates to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes,
And was it your understanding that Taylor Schabusiness was committed and she was sent to that facility for, mental health treatment, correct?
yes,
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Had you ever been made aware that she was under an order to take psychotropic medications?
No,
If I told you that she was civilly committed in April of 2021, where the court, a court of law, determined that she was mentally ill, would that cause you to have any concerns?
it would certainly be relevant, but it does fit with the information I already had, that Ms. Schabusiness was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No,
Did you know that she was required to take antipsychotic medication?
yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
Now, during your two contacts with her in October of 2022, did you get a sense that she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering from a mood disorder when you met with her?
Her emotional expression was odd when I met with her, but she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1, correct?
Yes.
With psychotic features, is that correct?
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Did you notice that Ms. Schabusiness was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
How much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use? Same thing?
I'm less certain about that.
Certainly, if you're using heroin or cocaine or drugs like that, that can cause brain damage as well.
Yes,
When you met with her, you did find that she exhibited some psychotic symptoms. Is that fair?
no,
In some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
no. And then to be clear with your last question, I did not personally observe psychotic symptoms during the moments of my evaluation of Ms. Schabusiness, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you. Did you see in the records there was a recommendation for her to be on Haldol?
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes,
Dr. Seipel was asked to opine on the competency issue, correct?
that is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes,
You had a chance to review Dr. Layton's report. Is that fair?
yes,
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
yes,
And do you agree with her findings?
no,
You would agree that Dr. Layton's report is more current than yours. Is that fair?
well, it was authored more recently, but the offering of the report has little to do with its relevancy because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's because mine was in closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at it is your, with due respect, your report is lacking because you don't have you haven't reviewed the Bell and Health records, correct?
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred in 2022 to be requesting records from when one was a teenager. Those would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Schabusiness tell you that she had no memory of the alleged events? When did she tell you that on both days? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when we reported the amnesia.
That was on October 21st of 2022.
Yes,
And in reviewing those Nicolay records, it's true that she was hospitalized, correct?
yes.
For about a month, right?
Um,
A couple weeks.
Somewhere between a couple of weeks and a month.
And that she was prescribed some medication for nightmares.
I believe that she was prescribed Abilify.
And
But I can
go ahead.
refresh my recollection.
Page 3.
Thank you. Okay, sure. She did say Prazosin for nightmares.
And it was such that when you talked with Taylor Schabusiness that she was actively hearing voices, those were the comments that she made to you?
Yes,
Did she indicate to you that she was hearing voices, in her cell?
yes.
Who were they of?
I think she was less clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing a voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
Extreme mood, like throwing a chair at a doctor?
What I gather that you're referring to is the evaluation of Dr. Lighton of
Yes.
Ms. Schabusiness. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
Did you have the occasion to review the report from Dr. Tracy Lucetta?
No.
This is a yes or no. You could have gone back to see Schabusiness after October 21st of 2022. Is that correct? Correct.
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
The fact is you didn't, correct?
That is correct.
Did you see, when you met her in October, you see her use odd or unusual facial expressions?
Yes, I believe there were instances of her smiling inappropriately.
It didn't track or it didn't follow, correct? It was out of context. Is that fair?
Yes.
Okay, I have nothing further. Thank you.
Redirect, Mr. Saunders.
Doctor, I want to pick up on questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time. And then that would be, based on my experience, that they can last as long as months. Oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episode. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of growing manic episode. Is that what you said?
Yes.
And can you explain why?
There are many reasons for a person to throw a chair. One of them could be due to a manic episode. But before I would make that conclusion, I would want to have compelling evidence that such a diagnosis is appropriate. And that would need to include objective evidence, meaning observation over time when a person is not being, thinking that they're being viewed, things of that nature.
So I guess then, would some of that objective evidence be to consider time periods both before and subsequent to the manic episode that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that it can be gathered by looking at behavior over time. When is the onset? Does it happen? I mentioned this earlier. Does it happen when people are not being, when they do not know that they're being observed? Things like that. And then there's more, the more objective evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Schabusiness, about her reporting or endorsing that she was hearing voices. Do you remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them was that they were represented some social anxiety, some rumination, her thinking about her circumstances. They seemed like more of an internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication. Maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for you observed in Ms. Schabusiness?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bell and Health records. You were aware that there was a prior attempt of self-harm previous in Ms. Schabusiness's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Schabusiness's use of methamphetamine at the time of these offenses. And I don't think that information generated 10 years prior would change that. So, so in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Ms. Schabusiness's records in the past. Is there?
Yes.
And are you aware of any of those symptoms that were reported absent context of methamphetamine use?
No, I am not.
And so like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
Then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No, my understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI 3.
Thank you, doctor. Nothing further.
Anything on those topics, Mr. Fraley?
Did she say that she had concentration issues?
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
Didn't give a lot of information, correct?
I disagree with that. I obtained a reasonable history from her.
It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Nothing further.
Anything on that?
No.
Thank you, Doctor. You can step away. Any other witnesses from,
No, Your Honor, the state rests.
any rebuttal testimony, Mr. Freilich?
No.
Okay. Ladies and gentlemen of the jury, the evidentiary portion of this case is now closed. So to give you a sense of what's next, it's similar to the process that you've already experienced, and that is I'm going to instruct you as to the rules of the law that you need to apply. The attorneys will make their closing arguments and you'll deliberate. I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up, so I'm going to excuse you at this time. All right, the jury. Be seated. So, counsel, I want to add some of the issues that you raised before when we were talking about the instruction. I don't have a problem delivering the instructions before you do closing arguments. And so I would probably take 160 and move it. And I want to just indicate the reason that I had proposed that is for this reason. When I look at 605, the last two paragraphs in 605 seem very similar to 515, which is read after the closing arguments before the jury goes out. And so I was looking for something as a way to kind of conclude the matter as opposed to the last argument is made and I just say, go. So my suggestion is if I read the instructions in the order that you've proposed, other than moving 160 to after 605, other than that, I'm proposing that I give a modified 460 just before the jurors leave. So after closings, I give a modified 460. 460 is the instruction, and I'm having my judicial assistant draft that up. That's when it says something's followed. I know you have heard before. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. It's that instruction. And the only thing I would eliminate is the second paragraph of that instruction, which says, you are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. I delete that paragraph because, first of all, this is a question of guilt or innocence at this phase. And secondly, because they're actually informed about the consequences of their action when I read 605. So I think that paragraph should come out. But in exchange for giving instructions before you close, my suggestion is give that modified 460 after your closings. I then swear the bailiffs and send the jury out. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
I gave you the proposed verdict forms, and what I noticed as I was looking at them, there's spots for the dissenting jurors to sign, but there was no spot for the foreperson. My judicial assistant is making that change. So what I'm going to do is I'm going to go make these revisions and then bring them back to you. But there are a couple of other things I need to call to your attention. First of all, change that I made in 100, the opening instruction, is in the third paragraph. You should have that. I put it in bold. That if any member of the jury has an impression of my opinion as to the issues in this phase, disregard that impression. That would take the place of the language that's given in the first phase. Is if any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty. So I switched that. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then Mr. Freilich, I need to speak with you, and perhaps you need to speak with your client about whether you want me to give 315. That's the instruction that your client, during the first phase, elected that I give. That's the instruction that says a defendant in a criminal case has the absolute constitutional right not to testify. And that's really, she has an option to have me give that or not give it.
Talk to my client. We both agree that you could read 315.
You're asking that I give that.
Yes, I am.
Ms. Schabusiness, you've had an opportunity to speak with the attorney about that decision?
Yeah.
Okay, I know you spoke with him about it at the beginning of the first phase. You'd like me to give that instruction in this phase?
Yes.
All right. I'll give 315. 640, mental disease or defect expert opinion testimony. The interesting piece there is that the last paragraph, the court has appointed, and then it says to fill in the name. Two of the people that were appointed by this court testified. Only one on the NGI piece, but two of them testified, and they both testified they were court appointed. And it indicates that you shouldn't give the weight, give their testimony any greater weight. I think probably both of their names should be in there, but I could see an argument that only Dr. Hingen's name should be on there because she was appointed on the NG on the other hand, both appointed by the court, and the notion that they shouldn't be given any greater weight than anybody else seems to apply to both of them. Mr. Saunders, any opinion on that?
Not really. I guess the preference would be to include both.
Mr. Freilich?
It would be my position that we would only use Dr. Christina Engine because she's the one that did the NGI evaluation.
Okay. I'll just give Dr. Engens. We keep pronouncing her name differently. I've heard it pronounced both ways. Is it engine, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Bang it, I think.
That's how I'm going to pronounce it. Moving on then to 605, there are some options that we need to address. And that is under the subheading meaning of mental disease or defect. I have some thoughts about which one's appropriate given the evidence. Let's just run through them. The first option is, because it indicates that in that particular portion, add the following if supported by the evidence. First, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I do.
That'll be out. The next one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included. Particularly well, there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear any doctor or professional say anything about antisocial conduct. So I would object to that.
I'm going to give that instruction for this reason. There was a lot of testimony about conduct that the average person could characterize as antisocial. And I think that's an important piece of information for them to have. So I'm going to keep that in. I note Mr. Freilich's objection, but that's going to be the order of the court. The next one, voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. I note that the parties stipulated at the last phase that that should come in. I'm assuming that's where we're at now, but Mr. Saunders, you're asking for that?
Yes.
Mr. Freilich?
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's, it's doubling up. The paragraph before is, I think, says enough. It's mentioning it twice, basically.
So
Well, I think the difference is voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking. And I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this to this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way? I would make that argument too.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect.
I was just saying it a different way, in my opinion, my humble opinion.
Mr. Saunders, any response to that?
yes, I think they're pretty clearly different. A voluntary induced state of intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis. So not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different. So I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this language should come in. The court should consider it. I asked, I believe, Dr. Engine and Dr. Seipel, and I believe Dr. Layton, that, using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor,
Yes.
it's crystal clear to me that this should absolutely come in. This young lady, Taylor Denise Schabusiness, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often. She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment. And it was clear, the records replete with the fact that she had a chronic problem with meth, methamphetamine, marijuana. So I think it's totally on point, and that should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
I think the focus is if the condition has become permanent, and whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case. I'm satisfied in light of the state of the record that it ultimately comes down to what the jurors heard. There has been a great deal of testimony regarding the use of drugs or alcohol. There were some questions placed to the defense expert about impacts on a person long-term using various drugs. I'm satisfied the jury can assess that. I'm going to give that instruction. Certainly, the parties can argue that they don't believe the evidence supports that particular aspect, but I'm going to give that piece. So I'm going to include that, and then that's the last option that has to be selected. I'm going to make these revisions then, and then I will give you a final copy of them, and then we will move. We'll bring the jury back in, and we'll move to instructions and closings. All right, we are in recess.
Thank you.
Session, your silence is requested.
Okay. Be seated. All right, you should have now a copy of the instructions that I propose to give to the jury. And again, I will give this before closing arguments. I'll start with the modified 100. There's one missing. Well, in any event, there's the add-on at the end of 100, but I'll get to that in a minute. I'm going to give 315. I'll give 640, the mental disease or defect expert opinion testimony. 605, instruction on the issue of the defendant's criminal responsibility. Then I'll give 160, closing arguments of counsel. Then you can do closing arguments. And then the closing instruction 460 after you've completed your closing arguments. I've added the verdict form, and the verdict form actually needs to have the heading on it. And I'll make sure that that gets corrected before it goes into the jury. But I did fix the request you had, Mr. Freilich. So the question one is, at the time the crime was committed, did the defendant have a mental disease or mental defect? And I did that for question two as well. And in the instructions, when I indicate you're going to be getting this verdict form, I made that correction there as well.
Thank you.
You know what? I think what I was thinking was missing. I don't think it is missing. I was thinking 602 needed to be inserted in 100. But that's true, but in the first phase of the trial. And so I think that's where I think I was thinking of 602, and 602 doesn't need to be inserted in 100 at this phase. Okay. That's what I propose to give counsel. I'm going to start with you, Mr. Saunders. Any objection to the form of the instructions or the verdict form?
Just on the verdict form, question one, I think it should read at the time the crimes were committed, plural, instead of the
You're
singular.
right. Because we're dealing with three, so that can be corrected. And then when I give 605, question one, at the time crimes were. Any objection to that, Mr. Freilich?
No, that makes sense. Crimes were, that's what we're talking about.
Anything else, Mr. Saunders?
Oh, there's one more instance. In the top of 605, the defendant's mental condition at the time of the offenses.
Sure. Makes sense as well. Mr. Freilich, any disagreement with that?
Your Honor, are we talking 605, the number one?
605, the very first sentence says, you have just heard testimony about the defendant's mental condition at the time of the offense, and they're suggesting it should say offenses.
I agree.
Anything else, Mr. Saunders?
I guess it's also next page, the first question heading.
What's on that same page, number one? At the time the crimes were committed.
Okay. Those are fixed. And I don't think it appears any other place. Anything else, Mr. Saunders?
No.
All right. Mr. Freilich, anything concerns about the form of the verdicts or, I'm sorry, the form of the instructions or the verdict?
Your Honor, I see what Mr. Saunders was talking about on that second page, where it's in writing. The first question is, and then it should say at the time the crimes were committed.
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says two questions, and then it's got question one and question two. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just wanted to make sure. Thank you.
And just so everyone knows, I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings. And so when this is delivered to the jury, they will have it corrected.
Okay, thank you.
In addition, as I've indicated, I'm also going to have the heading inserted on the top of the verdict form. So instead of the title of 605B, which is where this verdict form comes from, it'll have the heading in this case. If there's nothing else, then I'm going to use the same time limits as we had yesterday, but they're going to be flipped. So yesterday I gave the state a half hour and 10 minutes of rebuttal. That's what you'll get, Mr. Freilich, but the state will get 35 minutes for their closing. I'm not sure if you're going to need that much time. The time that I've given everyone each time, they haven't used, but I will keep track of that for this time.
Okay.
Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank you, Judge.
Very good. Let's bring the jury in. Which microphone are we using on the podium? That one?
Sure.
Right, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offenses were committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments, and as indicated, because the different burden of proof in this case, Mr. Freilich will start. Mr. Freilich, are you prepared to make a closing argument?
Yes, Your Honor.
Go ahead.
Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. Now, the question is whether or not Taylor D. Schabusiness is legally responsible for the crimes that she's been convicted of. And in this case, Taylor Schabusiness has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form. This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engine, and we have Dr. Lighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems growing up as an adolescent, and that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center, and that my client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home and she was there. And that was I would submit that was a pivotal event in her life because she loved her mother. Then we moved on to Dr. Diane Lighton, PhD, a doctor, forensic psychologist. And she provided testimony as to her extensive background, her training and experience. And she provided testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of post-doctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997, she went and became an independent forensic psychologist where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship. And so she testified about her background and her resume. Lawyers call it a curriculum vitae, her CV, bores out all of the experience that she has working in this field, technical field. And she went on to testify about the fact that she met with Taylor Schabusiness in February of 2023 at the Brown County Jail. And Ms. Schabusiness was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. Schabusiness in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County Jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records, looked at the Bellin Health records, looked at a lot of information. Basically, what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engine, she's the one that did the NGI evaluation. Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Schabusiness, Taylor Schabusiness, qualifies for the NGI plea based on her diagnosis of a serious mental disorder. The serious, she opines, she concludes, that the serious mental disorder affected Taylor Schabusiness's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health. She also says and opines that Ms. Schabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year. There was some talk about the feigning, the faking, the malingering. Feigning means faking. About that topic. And Dr. Lighton indicated that it was her opinion that my client was psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Schabusiness had a problem with methamphetamine, with drugs, marijuana, other drugs maybe. Dr. Lighton says that Ms. Schabusiness had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that. but she opines that her assessment finds that Taylor Schabusiness has a genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engine, with respect to her, she didn't know that my client was under a civil commitment order for Brown County by Judge Lee Joyce. Taylor Schabusiness was found by the court to be the subject of a civil commitment, and that's why she went to Nicolay Psychiatric Center. My client was also the subject of an order for involuntary medication. She had to take medications ordered by the court. No ifs, ands, or buts. Why? Because she was deemed to be having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account, that in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill. When you look at, the report from Dr. Seipel, or you heard about his testimony, I would argue that, his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately. But his focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with. And that is to determine if my client is NGI, if she meets that criteria. Dr. Seipel, although he's a PhD, his training and experience is much less than Dr. Leighton's. But his focus was competency, and that's not why we're here. Dr. Engen, she testified, and she met with my client on October 12th, 2022, and then again on October 21st, 2022. It appeared that on October 12th of 2022, there was some security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale. She didn't receive the Bellin records. She didn't look at those records. Someone else could have given her the records. Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors, which is something you should consider. There was no connectivity there. Also, with due respect, Dr. Engen, didn't trek from Milwaukee to the Brown County Jail to meet with Ms. Schabusiness to do further assessments or supplements. Didn't do anything to supplement the report. So that's something you should take into account as well. There's an instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here. We believe that Dr. Layton was very clear that Taylor Schabusiness has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear. She talked about the fact that Taylor Schabusiness heard the train, heard the whistle, that Miss Schabusiness lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale, that she has a very unusual presentation. And she testified that Taylor Schabusiness, when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions. But Miss Schabusiness was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr. Litton talked about hypersexuality, and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Ms. Schabusiness was washing her hands 30 to 40 times or touching her hair, things that were a cause for concern. You know, Wisconsin law, we all have to follow the law, and Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, that Ms. Schabusiness had a mental disease or mental defect, and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just 2, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request that you consider that, and that it was bipolar 1 disorder based on the testimony from Dr. Litton. Then number 2, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Schabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that that would be a yes. And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Schabusiness's mental condition at the time of the offense. So take that into account. It's a difficult case. It's a very complex case. Deals with law, deals with psychology, deals with mental health. A lot of things going on. But I would ask that you take all of this into account when rendering your decision. Thank you very much.
Jose, are you going to be giving? Saunders, okay, go ahead.
Thank you. Good afternoon. I think it was the dope. I think it was the dope. I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand. She even talks about she was still tweaking on meth during the dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth. And now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis. There's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. And you also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that. Instead, we're relying on a bipolar 1 diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion. And that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on or her ability to conform conduct, right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. And you heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case. Based largely, her opinion is, on her interactions with Ms. Schabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel's exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. for the last 4 days. There's no throwing chairs, there's no outbursts, there's no staring or off, right? So this idea that Dr. Litton's opinion based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you or that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball, right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert, Dr. Engen, observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Schabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. Didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. As he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert. And you heard the testimony, and if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or of a mental disease or defect. So when you're asked the first question, when you see the verdict form, That question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, do you get to the second question. Second question asks a sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense. And really, it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too. But it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes, where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor. I mean, what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over it? She said, yes. And why did she say it? Why did she say she did that? She was covering it up, right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct. She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you she knows exactly what's going on. She even remembers details about this night. And now that we hear this professed amnesia in her comments to Dr. Engen about this offense, and you saw the interview, she had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, and you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? It was pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up, because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law. And again, you heard nothing from Dr. Linton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Linton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging. in the time leading up to the offense, we heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so, and she did. You heard about her saying, well, yeah, I knew I was killing him, but quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect. We heard about the burden of proof, that it's a reasonable certainty by the greater weight of the credible evidence. And you should be, even though it's not our burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by the greater weight of the credible evidence that she does. It's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. There was additional jail records. They could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care, and you're not asked to decide, does she have mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing parents at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state. because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. That no, now the meth really didn't have anything to do with it. It's important to note a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.
Mr. Freilich, you have a rebuttal?
Yes, I do, Your Honor. Thank you. Your Honor, again, may it please the court, ladies and gentlemen, Mr. Saunders, Mr. Lissay. You know, this case illustrates that this young lady, Taylor Schabusiness, has a lifetime of mental health issues. She has bipolar 1 disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease that predated the incident that has brought us here to court on February 22nd of 2022. It's clear in this record that Ms. Schabusiness was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month in 2021. You got to see in phase 1 of this trial, Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. Schabusiness met, or Officer Russell met her at the door out on the porch. And you could see on the video her face. You could see her eyes. You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on. Did this happen when she was in a manic state or a psychotic state? I submit that, you know, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life. What we have here is someone who has a very serious mental health issue, mental health disorder. And you pile drugs on top of that. it can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay, she was under a court order where she had to have injectable antipsychotic medications. She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here. She has ongoing mental health issues. She's only 25 years old, and they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation, and that'll be something you have to think about. Is she able to appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it. It was very bizarre, very unusual, very odd, her demeanor. You know, in this case, there are a lot of doctors, but Dr. Engine, you know, she never knew about the civil commitment order. Come on. You didn't know about a court order? And she's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't know about this civil commitment order or this medication order. And then we have Dr. Seipel, you know, he got the Bellin records, got them from me. And, you know, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engine, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable. I don't make the law, but the law, you know the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that. The defense didn't fail. There is a plethora of evidence to show her mental health history. Was her bipolar 1 condition permanent? I submit to you that it was. Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Groff, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Schabusiness lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and she had were buddies. Words to that effect. So I submit that she did not want to do this. At the time, was she in a state of psychosis? Who knows? That's for you jurors to decide. But we've presented the lawyers, Mr. Saunders, Mr. Lassay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess. I would ask that you consider the fact that Ms. Schabusiness was taking the antipsychotic meds, the injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition. If you don't take your high blood pressure medication, what's going to happen? Your blood pressure is going to go up to the sky and you could have a heart attack or stroke. Same thing rings true for other medications. And in this particular case, Ms. Schabusiness did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff. I would submit that based on everything that's been presented, I'd ask that you consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do. All rise for the jury. Anything to bring up before we recess? Mr. Saunders? No. Mr. Freilich?
No, Your Honor.
All right, then I'd ask, as with the situation the other day, I'd ask if everyone remain around for 30 minutes until 6 o'clock or so. After that point, if you want to leave, if you could just leave a cell phone number where we could reach you. And with that, we are in recess. Thank you.
Yeah.